trial has culminated in conviction of the petitioner, and thus, is it correct? They none cut these. At the outset, the court is informed that the petitioner stands convicted pursuant to conclusion of the trial. Good so. Having regard to the process, the matter having become infructuous stands dismissed. Yes, next.
My Lord, I am appearing for vision. My Lord had directed me to file an affidavit wherein, my Lord, I have pleaded that the petitioner name was reflected in the FIR as Katiya Sahu, my Lord, but his name is actually Satugun Sahu. That I have given in my para 9 of my affidavit.
Okay, now come on merits.
My Lord, merits is this, my Lord, that she committed suicide, my Lord, but she was alive, my Lord. In my affidavit, I have given that we had taken her to the hospital, and in the hospital, she was alive, my Lord. And page annexure 1, A by 1, my Lord, page 4, in the affidavit, my Lord, we states that the people reacts to the light. So she was very much alive. So because of there was, my Lord, some kind of little bit disturbance, but not amounting to dowry or anything relatable to that. So there was some disturbance with the husband, my Lord, and husband has already surrendered. And there is a 4-year-old kid, my Lord, who has to stay with this in-laws, my Lord. So the both the parents, my Lord, of the husband, they are
The child will go to the mother's side. The mother's side can look after the child.
So, my Lord,
not be so concerned about the child. Child will be looked after.
No, my Lord, my Lord, on merit, my Lord, we have not made any harassment to the victim, my
That
Lord.
is your defense counsel. At this time for anticipatory bail, why should we go for defense? Your daughter-in-law has died under circumstances
My Lord,
which
my
are
Lord,
unnatural in your house.
in my house, but in my house, my Lord, may also see to this situation that I had taken her to the hospital. She was very much alive,
You
my
have
Lord.
to take her to the hospital. No, she was not very much alive. That is your case.
No,
She
I'm
was
not
very much
saying
alive.
I am showing that what was my concern, my Lord. I was showing that I was very much concerned.
Only as a defense, you are raising it here. We are not
My-
convinced. She
my
was
Lord.
not in a state.
My Lord, what? My Lord, we have never harassed her, never asked for any
Everybody says
dowry
that.
or anything.
Everybody says that.
My Lord,
That is the standard reply.
My Lord, we have never subjected her to any type of cruelty, my Lord. And my Lord, when she was,
Anticipatory bail counsel. Sorry.
my Lord, can I pray one thing, my Lord? My Lord, can the High Court order which has given me a liberty to move before the lower court on the same day, my Lord, can it be extended for another 15 days?
No, sorry.
My Lord, it has ended, my Lord, because
Take liberty. Now that will not extend. Same day we absolutely don't give. Very rarest of rare
no.
cases.
I'm not asking for the same day, my Lord. The Honorable High Court has granted me 1 month's time, my Lord. And before that, I had filed this SLP, my Lord. Only
So what? That 1 month time has elapsed much back.
My Lord, can it be extended, my Lord, for
No,
a
sorry.
period of at least 1 week, at least I pray.
Sorry.
1 week.
I will
1
consider
week.
the matter in its entirety. We don't find any case has been made out for grant of anticipatory bail to the petitioners.
I withdraw this. I withdraw that.
After some arguments, as paid for by your counsel for the petitioner, the petition stands disposed of as withdrawn. Yes, next.
May I please, Vinod? Because I appear as a amicus in the matter. The last date of hearing, my lords had directed the learned AST and me to file a concrete.
We have always been cajoling you, come out with a common minimum.
Because we have.
And have you made a distinction? Very clearly, I remember that I told you to make a distinction. The parameters cannot be same for all. There has to be various levels of these clinics. One is to be in the villages. You can't expect them to have a ventilator and everything. Absolutely not. No private. So you have to have different parameters, but yes, some basic parameters at every level. Basic hygiene, basic equipment, basic qualification, that we can understand. But that is why, because we are not very much into the nitty-gritty of the thing, and it has to be at a really practical to make it workable. Otherwise, again, there will be violations, and who will gain? It is only the corrupt officers who will gain from this.
Well, it's
Because
led by the learned ASG.
Yes,
The central government sat down with the amicus,
yes.
went through the suggestions, and my lord, we are carrying.
Counsel, you are on the wrong. Amicus is only a friend of this court. We asked you to involve the stakeholders.
My lord,
The problem, the cutoff is the government thinks itself to be in a glass.
my lord,
glass.
Because
This is the way you deal with it.
Because
You don't call the persons the affected persons.
we actually interacted with all the
all the stakeholders.
we all
States against states is what?
the
Did you constitute?
Secretary Health of
So easy. Absolutely thoroughly incompetent persons holding the post without any background. You are on the wrong direction, counsel. We thought the amicus at least would have some sort of a sense of direction, counsel.
May kindly look at my note. Because
No, we'll not look at the notes. We are not here to decide. It's not an adjudicatory or what you call adversarial litigation. Then what is the purpose? Outrightly we reject. If there has been no consultation with the stakeholders, we reject it outrightly. We are disappointed, Mr. Amicus. Absolutely disappointed. We said we did not mean that it will be the government, only at the government level. Government to government, they think what is best for the people.
Because in the
This is the disconnect we have.
because may I point out to this?
All I words, democracy, for the people, by the people, of the people.
May I point out to this?
All empty words.
The secretaries of the state and we have also interacted with the doctors which were appointed by the state secretaries to interact with us to give us practical problems.
They must be all government doctors.
Please, all government doctors.
Sorry, we reject it.
See,
Look here. Very
as
disappointing.
amicus, you must understand the problem is not specific to one particular area.
Yes, please.
You must also appreciate one thing, that our medical system is resilient, strong, and sturdy. At the testing times, it has proved to the international fraternity that our Medicare is one of the best in the world. But a few mistakes here and there are happening. The whole objective is, instead of court saying, someone else saying, that in respect of each one of the states, someone who are bestowed with the authority of overseeing. For example, earlier we had Medical Council of India.
Yes,
Now in its place, what is the name of
National
that?
Medical
Huh?
NMC, National Medical Council.
Medical Council is there. Each state has a chapter. Each state has a health university. Under health university, we have both government colleges and private colleges.
Yes,
And they have structured distribution of the Medicare also.
please, Manoj.
Depending upon the footfall, depending upon the patients, they can set down the requirements for each one of the situations. One. Number two, we are very happy that youngsters who are interested in good health, they are present in the court. But we are very sorry to note that no responsible lawyer from any of the states is present before us. That is another aspect which is causing little bit of anxiety to the court. We are not expressing it in the form of anguish.
Because I understand this matter actually has been going on for a long time. And some
All youngsters are sent.
Because
We thought,
may I
See,
point out one thing?
no, just hear the order. We'll tweak it. Just a tentative.
We just take into consideration one thing. Because what fell from my Lord Justice Bhatti, because the health happens to be a state subject, not a central subject.
That is not the issue, counsel. That is why we never applied a judicial mind to it. This service, this state.
Allow me to formulate it. Because however, there is a central act called the Clinical Establishments Act. Being a central act, it has been adopted by 16 states, not by all states. Under that act, there can be some regulations framed by the center which are mandatory for all public and private clinical establishments. Now, the issue of whether such regulations should be mandatory or should be followed across the country is already pending in a petition which is going on before my lords. In
Just fast here, I will get the details.
so
That is before which court?
Well, I'll just get the details.
that question is also being considered by this honorable court.
See, where is the learned ASG?
Well, she's on her legs, my lords. May consider passing it over if my lords wants to hear her.
No, just hear it in look here. At the outset, Learned Amicus Curie submits a report, which according to him is the outcome of consultation with the state health officials as well as the central government. Full stop. On a direct query of the court with regard to the persons who are involved and who gave inputs before the report was finalized, we are informed that there was no representation from the health providers in the private sector. Full stop. Including corporate hospitals. Full stop. In such view of the matter, we think that the exercise may not be as envisaged by us. Full stop. Accordingly, let all the states have a regional conference, one-day regional conference with representatives of all the stakeholders in the state, deliberate about the issue in the present case, and come up with standardized procedures for running private medical facilities, stroke clinics, stroke hospitals. Also, we indicate that it would be limited to the minimum requirement, which is practically enforceable, and the foremost objective would be that the nature and quality of service, medical service to be offered is not compromised in any manner whatsoever. Full stop. By this we mean that the basic requirement of ensuring the quality of the personnel, the quality of the medicine to be provided, the standard of hygiene required should be discussed and suggestion made. Full stop. The states will thereafter formulate the issues and the recommendations in terms of what comes out in such conference, and thereafter it will be forwarded both to the amicus curiae as well as the learned ASG, Ms. Aishwarya Bhatti. Full stop. They will then, full stop. In the meantime, it shall be open for the central government also to hold such an interactive session with the national bodies of the concerned doctors, stroke paramedics, stroke nursing, and any other aspect, and any other stakeholders which may be relevant and are required to be consulted. Full stop. It would be on the same pattern as we have prescribed above for the state government, which is to say that all stakeholders from all fields, including private clinics, stroke hospitals, stroke corporate establishments, shall be consulted at the national level, that is, through their apex bodies, if any available. Full stop. At the central level, and both at the central level and at the state level, it shall be open to the central government and the state government to co-opt any eminent doctor which, according to them, would be in a position to give useful suggestions, which shall also be taken into note before formulating a final draft of such resolution. Full stop. Whatever has come till now may also be factored in and suitably reflected in the final draft proposal stroke resolution, which will be placed before the court. Full stop. Such exercise be completed within 6 weeks from today. The matter be listed, give a date after 2 months. The report submitted by the learned amicus is taken on board. The report be taken on record. Submit. I think that is clear. Full stop. It is made clear that this state level conference shall be directly for the state level conference. The concerned principal secretary, stroke the principal secretary or whoever may be the head of the Department of Health in the relevant states shall be responsible and shall also attend the meeting, and the resolution which has to be final resolution which has to be forwarded shall be under his signature. There shall be no departure from this, as it is as the direction is mandatory in nature. Full stop. The same standard will apply to the central government, where the final resolution will have to be signed by the health secretary to the government of India. Full stop. That is the clarification. Yeah, it is also made clear that the state governments would cooperate fully with the central government stroke learned amicus stroke MS Aishwarya Bhatti if they may require any further clarification stroke assistance while preparing the final draft. Full stop. The matter be given utmost priority. We make it clear that this matter has to be given utmost priority as it deals with the life of the common citizen of this country, which cannot be allowed to suffer further, and more so since the present matter is pending since the year. When was the first? For quite some 2016. That is almost a decade. Yes. You were next year, exactly after 2 months.
Can I make a request?
Yes.
On 23rd of July 2023, I also passed a direction directing the registry to add the amicus column to the web portal so that I can actually file. Because the registry does not consider me a friend of the court, I still cannot file, Milos.
There was a direction?
Please, Milos. On 23rd July 24, Milos.
23rd July 24.
My lords, we have the last paragraph of that order, para 9. Para 10, I'm sorry. Learned amicus curiae submits that he's been facing difficulty in accessing the electronic file in the instant case because the category of amicus curiae has not been mentioned in the web portal of the Supreme Court, which only recognizes those mentioned as petitioners and respondents. He submits that such a direction will enable all amicus curiae appointed by the court in different matters to access e-file with ease and to file documents, papers, etc. The registrar IT is directed to examine the aforesaid and make the requisite changes to the web portal.
Call the SI.
Status, it is showing for the court assistance, current Bharate, amicus curiae. It is protecting in the case status.
So when I try to file in the e-portal, it only says respondent and petitioner. I cannot file.
No, just do one thing. You call them, we'll direct him, you go and talk to him for 10 minutes.
Please.
And then if anything more judicial order is required, we'll do that.
Please.
Otherwise, if you can sort it out at that level, call him and both of you will sit together. Just call him. Yes. I think that covers up the entire gamut. It is also made clear that the court seriously views non-appearance of learned counsel for the states before the court when the matter is taken out, comma. Accordingly, we propose to mark the attendance of counsel from each and every state, and the states who were not present would have invited strict orders from us. However, we refrain from doing it for today, but from the next occasion, comma, if any state goes unrepresented, comma, the repercussion would be for the state government. State would be direct, it will be a direct comment on the concerned state government, and they would be inviting strict orders from this court. We make it very clear.
Council who are already states. We are all for the states and union.
No, not everybody. Can't be everybody. Should we start taking attendance? Should we start taking? No, you can give physical evidence from sitting out. Somebody told after half an hour, somebody will come and give physical experience. But everybody is not there. That is why we said everybody is not there. We are refraining from passing.
But
The moment it is not done,
it will be misread.
it will be misread. It should be misread. So whoever is here, you give your appearance.
Physical appearance.
Yes.
Do one thing. No, do one thing. He will be there. Whoever comes, if they give a
AOR, please.
only AOR and ask him what his name is. The AOR has to give it right here, and that will. It is 11:05. At 11:15, no more taking of slips. We'll mark the attendance.
So we are.
Whoever is appearing personally, only one name will be given. Person, and that person only has to give. And at 11:15, the window closes. You go there. Everybody will come and physically show him or her to the master. We are not taking any cognizance. We are not taking cognizance. What we have told, do that. Within 10 minutes, the window closes. High time. There will be
Your Lordship,
everybody
Your
there.
Lordship,
Only a slip will be passed.
Your Lordships, I'm appearing for the Your Lordship, I'm appearing for the state of Mizoram in this matter.
When he comes, he shows them and tell him practically let them sort it out.
Your Lordship, I'm appearing on behalf from the office of the Standing Council of State
Only
of Mizoram,
one
Your
name
Lordship.
and you identify. Good
Your
master.
Lordship,
You have to see only one name and you have to ask what name is that. That other person cannot give another name.
yes, Your
That
Lordship.
person only has to give.
Yes, Your Lordship. We will do that. Your Lordship, if you're given appearances virtually, Your Lordship, that may be.
No, we disapprove VC.
I apologize, Your Lordship, but
You apologize.
I've been
You
given
tell
the
your friend-
appearance.
You tell your friend and to write your name through VC and then we'll check up whether you were there on the VC or not. We'll check up.
I will place the appearance, Your Lordship, on the
Yes.
chat box.
All of them start attaching when we hear the order. Otherwise, everybody was not even bothered. Just a window is open and they're doing other work. We know how VC works.
Your Lordship, my camera was
They
open.
shows the lack of seriousness. Let the government also know the lack of seriousness of the council before this court, especially in this matter. Yes, call next.
May it please your lordships. Item 7. May it please your lordships, I'm appearing for the petitioner.
Yes.
In this case, accused 1 and 2 have been convicted under section 302 IPC and sentenced to rigorous life imprisonment with default clause. The allegation against them is the accused 1 and 2 assaulted the deceased on the ground that he had committed a theft of a bicycle, and this assault was done by accused 1 and 2 with the stick on both his legs, waist, back, and near the mouth. Now, your lordships, if I can just show your lordships the post-mortem report over here at if I could just show your lordship the deposition of Dr. Deepak Prakash PW12.
will take.
Yes.
Of all, I don't expect from you. No, take it.
No.
Give it.
We told you by 11:15. Still
Yes,
we have 3
give it,
minutes.
give it.
3 minutes still
Still
left.
have 3 minutes.
But next time be present. Don't take this because it's a group matter and my term will not be called. Don't do that.
No excuse.
No excuse.
Please
If it
don't-
is here, either you take a choice, either there or here.
Yeah.
If you're not here, then your state will suffer. You directly hold the state responsible. Yes, next. 7. Yes, Council. Proceed.
Yes, Your Lordship. The FSL report with respect to C6 lathis is negative, and also with regard to the presence of human blood. Your Lordship, most of the prosecution witnesses have turned hostile. I shall also name them PW1.
You are saying most. Come that whoever has
I
remained
think
is not.
PW3 remained steadfast.
Yes, he is the father of the deceased. Yes, he remains steadfast. But again, PW2's deposition has been refuted.
There's no past enmity for him to implicate you. And very correct. You were enraged because of the theft. So father says this, why would you protect somebody else? He very genuinely says, what was the reason? And we accept. It happens. For accusing somebody of a theft and all, people get enraged. So it is very natural. No past enmity that he'll implicate you. Nothing. Why should a father say a wrong about and protect the real culprits at the cost of saving the others?
I mean, the person, if the accused 1 and 2 were enraged, they hit the accused, which is an admitted, they hit the deceased, which is an admitted fact, but there was no motive.
Motive was that they were accusing him of theft. That is the motive. Wrong motive. It is not on the spur of the moment. They accused him. That means they had come with fully prepared that yes, he is the culprit. He has to be taught a lesson. So that is the motive. What more motive can be there?
But I mean, Manoj Rathia.
So not at the spur of the moment. They came prepared that because he had stolen, we'll put him in his place. We'll teach him a lesson. And you
See,
got a lesson for now, not require any more lessons.
Your Lordship, at page 58, para 47 of the trial court judgment, where the defense witness was called D1.
Yes.
If I could just read para 47.
Yes.
Hirolal DW1 was called in defense on behalf of the accused. The witness stated that on the day of the incident, they had gone to the forest to graze sports with Manoj Rathia at 8 a.m. The forest was about 3 kilometers away from the village. They have returned to the village at 6 p.m. after grazing the goats that day. The witness also says that on that day, Manoj Rathia was grazing goats with him from 8 a.m. to 6 p.m. So this has been refuted by the DW1 and also PW11.
No, what I'm trying to, we don't get the point.
Your Lordships, the petitioners 1 and 2 had called in the defense witness, and he says Manoj Rathia was with him grazing goats the entire day, and the place where he was grazing.
We are not inclined to believe on that. Defense witness.
And
says,
PW11 and 17 never supported the Caesar or the memorandum.
Okay, we met at some point, we'll issue notice. Nothing more than that. Yes, issue notice. Give it after 2 months. Yes. Yes, 8.
Next.
Yes.
Lord, in this case, Lord, there was an order in my favor, Lord. Now they say that order is on ex party, Lord, whereas that order was passed on a merit, Lord, and both the parties were heard, Lord. Lord, if Lordship will have the page number 55, Lord, it has come very specifically. The report was pursued and arguments of learned advocates were heard by me, Lord. It has come for both the parties. They were even not, respondents were not even party, Lord, for village pradhan and all, my lord, they pleaded himself party and they were heard, my lord. After that, it's reason order.
Where is it that they have been heard?
My lord, page number 55, my lords. Page number 55, my lords. PDF page number 74. The order dated 4/1/25, my lord. Lord, the record was pursued by and the argument of learned.
We're not bothered about the records. We are bothered about whether hearing was.
Yes, my lord, there is that. And the argument of the learned advocate were heard by me, my lords.
Advocate doesn't mean that advocate also, because there are a lot of other respondents also.
My lord, they are
Just
advocates,
advocate.
my lord, definitely they will heard, my lord. And my lords, after that, my lord,
There cannot be a presumption of definiteness.
my lord, if lordship want, I can file the order sheet as well, my lords. Because, my lord, there was a presence mark in this case, my lord,
Counsel.
without that.
Counsel, why do you leave it to us?
No, no, my
If
lord.
your lordship wants.
My lord,
You don't
that
want
time it was
anything.
not
We want
available.
you to convince us.
No, no, I apologize, my lord, but that time it was not available with me, but I can bring it on.
In a case like this, the best thing is you must inform who are all the advocates who appeared for the parties.
I will
We
file the
can
order.
establish that at the time of hearing, the advocates were present.
My lord, I just
Not from
the
the
order
solitary
sheet, my lord,
sentence.
I will file it out. I can.
No counsel, show from anywhere that they have considered that the stand of learned counsel, that is, he cannot just peruse and pass an order.
Secondly, copy is also sent to the advocate who appeared for respondents.
My lord, these proceedings are done in the lower judiciary, my lord. They are well informed, my lord, and they are present always in these proceedings, my lord. My lord, but
Sorry, we are not going to general. Show even one line that the court has discussed the case of the other side.
my lord, for that's why I'm seeking permission of.
No, sorry, the order has to speak. We are not going to hear.
My lord,
We are not going to let it be supplemented, heard or not. If it is unconsidered, then on that ground itself.
On record, my lord.
No, sorry. You have to defend the order as it is. You show that in this order, there was consideration. He just says, peruse. He will
Consideration is
decide
of
on
the
his
entire
own.
fact of the case, my lord, and with after
Sorry.
them, my lord.
Sorry.
And my lord, one more thing, my lord,
Yes.
I point out, my lord.
Yes.
My lord, kindly have the impugned order for a moment, my lord.
Yes.
My lord, the impugned order says, considering the fact and circumstance of the case and on my undertaking for the petitioner, my lord, the order dated 4/1/25/81 and 4/3/5 are hereby set aside, my lord. My lord, there was a correction application by the petitioner, my lord. If lordship will permit, I will produce before this honorable court, my lord.
Yes.
They says that 4/1/25 order stands corrected. We have not set aside that order, my lord. Now, my lord, if there is a fresh hearing, what will be effect of that, my lord? The 6A application is decided, my lords, and after that, the
Everything
court
will-
moved an
Everything has to be set aside. Otherwise, that means there is no
Lord,
remand.
there is a correction of this order, my lord. That's why I'm saying, my lord.
Sorry, it has to be heard again. Having considered the matter in its entirety, we don't find any ground warranting interference by this court. Accordingly, the petition stands dismissed.
I'm obliged.
Yes, next.
Yeah, please, this is a legal aid matter. You transfer petition on behalf of the petitioner.
Legal aid, so that means we have to give you some extra crutch.
Just
Is it-
specific, not,
Why? What? How is it relevant? Legal aid matter?
my lord,
Then come out of the legal aid. If you are so, you want to have the crutches of the legal aid. I absolutely find it disgusting. A council opening his mouth legal aid as if you are doing charity to a person.
my apologies. My apologies.
Legal aid, standing up and
My
legal aid matter.
My lord, the respondent has been served with notice, but no one has put up the presence till date, my lord.
The private respondent.
My lord, private.
Yes, who's for the state?
State is not a party here. No, this is a transfer petition between husband and wife.
This is the item number.
It's item number 9.
So you are seeking transfer of which case?
Transfer of divorce petition from Family Court Kurukshetra, Haryana to Rohini District Court, Northwest Delhi.
Yes, same order. Despite service of notice, nobody appears. Having considered the matter, allowed, same order. Yes, next.
Obliged.
Item 10, my lord, I'm appealing for the respondent. On the last occasion also, petitioner did not come up to my lord, has passed over the matter and thereafter the matter could not reach.
On the last occasion, you took time for file.
Thereafter,
Counter
the matter
affidavit.
is again, my lord, but there's no order sheet because the matter was.
Have you filed counter?
Yes, my lord, we have filed counters.
What is the stand on the transfer sort?
My lord, the child lives with us since her birth, and the petitioner has left the child when she was in 3 months old. And now all of a sudden.
Child is with you.
Yes, my lord. She is now 5 years, going to be 5 years in the month of September. She is with me since her birth. And she has never seen her mother, and she is not aware about any culture or anything about her.
No, the mother left How soon after birth?
Yes, my lord. The
How
child.
soon?
Sorry.
How soon after birth did the mother
After 3
leave?
months.
Why?
The child was in 3 months. There was some dispute between the husband and wife, and then
So the husband's family must not have allowed her to take the child.
it
That
was,
is what generally what happens.
it
No,
was
you have to
filed-
not go alone.
but
Child will not go.
she has never filed any FIR. She has never filed any complaint.
We don't know. Maybe she is not in a position to appear. What does she do? What does she do? Is she employed, working? What does she do?
That I don't know, but family has contacted her many times to come and meet the child, and she has signed one paper also that she'll be visiting the child, but she has never turned up. She has filed a maintenance case in Jharkhand for asking the maintenance for a child of 30,000, and the child was not with her. Then that prayer was amended later on.
Amended to?
Amended for the maintenance to her because she has asked for 60,000 maintenance in total, 30,000 for herself and 30,000 for the child.
Any money being given on that? Any interim order?
The maintenance petition is still pending in Jharkhand. She is staying in Jharkhand.
Not even interim maintenance. You're not giving even interim maintenance to her. Then how should be conducting a case here? At least interim maintenance you should give to the wife. Okay, for the child, because child is with you, but she's your wife. You have to give maintenance to her.
Please, this matter is pending, my lord. We'll definitely come.
No, then you first pay. You first pay, then we'll put up after 2 weeks. Look here.
Please, my lord.
No, nobody has appeared on behalf of the petitioner wife and learned counsel for the respondent husband in present and has also filed counter affidavit, semicolon. However, comma, from the facts which have come to our notice, that is, the petitioner has filed case taking maintenance in Jharkhand, which is pending, and there is no order even for interim maintenance, comma, since the petitioner is still the wife of the respondent, comma, we deem it appropriate that she gets some money both to lead a normal life as well as for her expenses, including conducting of the case, present case before this court. Full stop. Accordingly, comma. What are you doing? What is your vocation?
I was working in a bank. I'm the manager in the bank.
What do you mean I was working?
I was in Bangalore and then I have shifted to Kolkata. Now I'm with my child and working in a bank.
You have got good money. Bangalore and then Kolkata. So we deem it appropriate to order payment of how long she's been away from you?
2021. She has left the house.
For 4 years, you've not paid anything.
But
Say
my
something.
lord, I have just got the instruction. She has not asked for any interim maintenance as of now. She has even filed a custody case where she didn't even appear.
You're right. We are asking as a court. It is our duty.
I'm seeking instruction, my lord, on that. But if my lord may see my counter affidavit, you can understand the conduct towards the child by her, my lord.
Is the child fighting?
Child
is the
is
husband
not
right?
fighting, but
So because of the child, she will lose her right as a wife.
But my lord, she has filed a custody matter and she has never appeared.
So she'll not get the custody. So we change the position that she is your wife, your
In
wife.
respect to maintenance, I'll seek instruction, my lord, and I'll get back to you.
The litigation under Hindu Marriage Act, one has to pay expenses.
Yes. So you have to pay expenses. The last 4 years,
I'll take the proper instruction, what the stages are, and I'll get back to you. My lord, may put it after 2 weeks.
No, we propose that we'll give her about 50,000 rupees lump sum upfront. Then whatever is decided that we adjusted. But now because of a non-appearance, we have serious doubts whether she's in a position to conduct this litigation. From Jharkhand coming here, it's expensive.
Well, there was an advocate. She is the one who has filed a transfer petition, my lord.
You are right, but then whether she's in a position, who does is it pro bono or not?
No, it was not.
So she also needs money, and you have not paid since 21. Courts intervene or do not intervene, your liability is there. So why should you not take
Once again,
judicial notice?
come back to.
Look here, no, still, however, in view of the fact that the parties are living separately since 2021,
January 2020.
not even, and no money has been paid for as by way of support by the respondent husband to the petitioner wife, Mama, on a query of the court as to why some lump sum interim amount be not granted to her, both for her upkeep and also for pursuing the litigation. Former Land Council seeks time to take instructions. Paragraph accordingly. Next week,
Please, Malam.
the matter be listed next Tuesday. Come with a reasonable amount.
Please, Malam.
50,000 is very less. Maybe we'll increase that, but you come with instruction.
Please.
We don't know. Yes.
Please. This is a transfer petition for transfer of a divorce proceeding from Ahmedabad to Aligarh.
Yes.
A rejoinder affidavit has been filed by wife. Kindly see page 9 of the rejoinder affidavit. There was a settlement between the parties. Joint petition was filed for annulment of marriage. That was dismissed in default. She did not appear. So she kindly see the page 9.
What is this?
Page 9, para 9.
Page 9, para 9.
Rejoinder affidavit.
Yes.
That on the basis of agreement. So she's got it.
That is a settlement agreement.
But it's
Yes, Lord. Yes, Lord.
This is a
That's
divorce
correct.
proceeding in Ahmedabad. The joint divorce was also filed in Aligarh. I'm seeking only a transfer from Ahmedabad to Aligarh.
No. Your conduct. When you sign and file a joint petition and you don't.
I didn't file. We both filed. Then after that, we started living together. That's why we both didn't appear. That is why the petition was disposed for non-prosecution, because either side was not appearing, because we started living together.
Yes, you
And
said
this
that
is
she did
being
not
shown.
appear.
Worship, kindly see page 3 of the petition. Page 3 of the petition. Page 3, para 9. She, on the first date, she appeared. Thereafter, she did not appear. I appeared again.
Page 3, para 9.
Minutes, he has in his
Page-
counter
page
affidavit, there is a
Counsel, we are hearing the other side. Yes.
Page 3, para 9 of the petition.
Of the petition.
Lordship. Of my counter affidavit. I'm sorry.
of the counter.
I'm sorry. Of my counter affidavit.
Yes, place it.
Page 3, para 9. On the first date, appeared both. Thereafter, she did not appear. On all dates, she was absent. I appeared on 2 dates again. Then it was dismissed in default. Lordship, she has received all the amount, lump sum amount she has received. And
So according to you, whatever were the conditions specified in the agreement has been complied with you. Where is your statement? That from your side, all the liability has been discharged?
Lordship,
Where is the sentence?
Where is it? That you have completely discharged your
yes, Lordship.
obligation under the section.
Yeah, Lordship. Page 9 of the rejoinder affidavit. Page 9. In her rejoinder itself,
Yes.
the petition, section 13B, petition has been annexed. Para 9, Lordships.
Yes, read.
That on the basis of agreement between both the parties, before presenting the petition, party number 1, that is the wife, has received the amount in lump sum from party number 2 towards her maintenance. Party number 1, party number 2 will not file any suit between themselves after today. And if it is filed, then it will be automatically be void and ineffective. Next paragraph. that on the basis of the above mutual agreement between the parties, whatever goods belong to each other have been exchanged. Next, that party number 1, that's the wife, has received all Stridhan and goods from party number 2.
There is no collusion between the parties.
Thereafter, she has filed maintenance and domestic violence act. Then, Lordship,
So you filed a petition in court council, pressed or do not pressed, doesn't make a difference. You have signed
Well,
it.
this is
You
yes,
have never taken the stand that this was, I'm withdrawing this was under coercion or some.
well, it's the order sheet that was being shown in the counter affidavit.
Forget about the
last
order
day.
sheet. What we are asking, answer the query. You sign it, you admit everything in a
Because I'm
court.
not denying it. I'm
So,
not.
so you're
But
bound.
this transfer petition is about a divorce case, not.
Sorry, everything has to be taken in its entirety. Everything was settled.
Well, it's
Okay.
then after that party started living together. There's a.
We are not bothered about after that.
Then para 9 also says that there will be no further proceedings filed by each of the parties. Then the divorce petition should not stand. If that is the stand, Millards, in para 9 here itself it is written. If I am bound by my statement, he's bound by his
So
statement.
you take that stand here. We are only looking for a transfer.
Well, it's only
Not-
transfer of a divorce
So we
case.
are not transferring it.
You are
We
very
don't find
correct.
it.
Well, it's even this mutual divorce was filed at Aligarh, not in Ahmedabad. Both filed it there. I'm there. I'm employed there. I'm a
Whatever is
government teacher. I have
there-
a 2.5-year-old child.
Whatever is there, we are not inspired to. Yes. What is the reply? Why after that you filed the divorce and nobody had to file any other?
Lordship, she has filed maintenance petition and the domestic violence act petition. Lordship say, I want the divorce. That's why this petition, because everything has been
No,
settled.
no. So you filed it after you
Everything.
filed maintenance and domestic violence. After that you filed divorce.
Lordship, everything has been settled.
We are
Then
asking you a different question.
Lordship,
Is your divorce case after her filing maintenance and domestic violence
Yes.
case?
please, Lordship.
So no ground. Okay, having considered the matter, we don't find any valid ground for allowing the petition for transfer of so and so from so and so. Accordingly, the petition stand dismissed. Call next. Yes.
Grateful, Lordship.
Well, it's permit me to participate through VC then.
You have to make a request to that court. We are not here. That is the rule.
Well, it's
They are
even
there.
the proceeding
It
was
is not-
filed at Aligarh. It was never filed at Ahmedabad.
Yes, call next.
Grateful.
Yes.
So item 12, I'm seeking a passover as I'm being led by Mr. Devdutt from agencies on this next in court.
Yes. Next.
Item 13.
Lordship, in item 13, I'm seeking a passover. A senior counsel occupied in photo number 2 of the circuit.
Yes, next.
Lordship.
That's it, kindly pass over. Item 14.
Yes. Yes. 15 who's appearing?
14.
Putting password.
Lordship, 15, I'm requesting for a passover.
Yes, next.
Wait. 16 minutes.
15 minutes, sorry, minute. 15 minutes, respondent number 2 died. Minute. I will take steps to legal as.
Respondent number 2 died. You are respondent.
Yes, ma'am. And for the respondent 1 and 2 minutes.
Petition has to take. Why are you bothered? You have not been done.
Give them copy minute.
Please check in a password. Huh?
What? Give them the copy minute.
Give them a copy of what?
The death certificate as legal certificate.
Okay, at the outset, in 15. At the outset, counsel for the respondent number
2 minutes.
to submit that he has passed away. However, to hand over a copy of the death certificate to enable to the learned counsel for the petitioner for taking appropriate steps for substitution. The matter be listed. Due date after 3 weeks. Yes.
16.
Great.
16 minutes. There are two aspects of the matter. The first is the
15.
15 passport. 15 has been disposed of. Yes.
16. There are two aspects. The first is the delay, which is substantial, and then there is the merits. I'll first address the delay, because the delay is about 2,600 odd days. It's just
Three lodged.
Yes.
How do you explain that?
Yes, my lord. Lord, please have the dates, my lord. I filed, my lord, after the Labour Court has decided against me. Immediately I go to the writ court, my lord. The writ court, my lord, the single judge dismisses my matter, my lord. The Labour Court's order is of 25/6/2012. I immediately go to the writ court. The writ court dismisses my matter on 14/6/2016. Immediately thereafter, writ appeals number 1, 2, 3 of 2017 are filed, my lord.
No, counsel, today it is only on IA number 23111. But it is only limited to 23111 for seeking permission to withdraw. So I'm not hearing on
Heard the matter, my lord. It's a very short issue otherwise.
No circuitous way. You file it now innocuously for withdrawal and then you
No, not
take the court. Yes, today is only IA.
Yes.
What else for today it is only for IA. Why would you consider it?
Last week,
You have filed an IA?
your lordship said.
He filed it.
Take up the-
That is listed. So we are not hearing the main matter. You can't say efficiency, go through an IA and then come to the, if it is not being early heard, so file an IA.
My apologies, my your lordship.
So you should not have addressed. You knew the list was, you thought that.
Last week, your lordship said indicated your lordship said hear the matter instead of the IA, my lord. That's why I
You are prepared to
began the merits.
Yes.
Wait. So, my lord, in 2017, my lord, I filed, my lord, the writ appeal. During the hearings of the writ appeal, I have discovered, my lord, I learned that the writ appeal is not maintainable. Immediately thereafter, my lord, I file a memo for withdrawal of the writ appeals, my lord.
So how soon did you realize that writ appeal was not
My
maintained?
lord, 2023 is when I realized it, my lord, because it's.
And when did you file?
Yes, my lord. The delay is 2600.
When did you file?
I filed it in January of 2017, my lord.
And then in 2021 you realized.
2023, I have filed memos for withdrawal of the writ appeal.
So it took you
And
6 and 3.
yes, my lord, and
4 and 3, 7 years to realize this.
2600 days, my lord. That particular council has passed away. I don't want to.
Oh no, we don't.
But
We don't have.
your lordship may only consider, my lord, on the 2nd of November, that was withdrawn, and 18th November immediately I have filed these SLPs. In fact, your
You have a right to withdraw at any time, but that you will not be getting premium because after 7 years you realize that it was the wrong.
Yes, my lord, I can't make that better today, my lord. But may I just show your lordships a couple of things, my lord, just to, my lord,
Will not let you enter into the merits.
Lord, the reason why, Lord, I want to show your lordship the merits is the judgments of your lordship's court, Lord, now on 25F say reinstatement is not the natural consequence.
We have to go into that far.
Yes.
We not cross the hurdle, the big wall.
The reason why I'm indicating that if 25F, the formula that your lordships have laid down, my lord, if that formula is applied, each of them will get about 7,000 or 7,000 odd rupees.
Sorry, counsel,
Now
we are not hearing you till that level, at that level. We are hearing you that you take action against whoever you want. For 7 years realization, we are not in time.
Your lordship said to issue notice both on the...
Now we are wiser. We have seen. You can't afford 7 years, leave them in the lurch and then come here. And then suddenly, we find issuing notice is absolutely nothing. We do it on the spur of the moment. It's a toss. Who gets here or gets there. That is not a ground for us.
Case law on delay.
Sorry.
But your lordship.
So you have to suffer. How you realize it from who officer for what? 7 years of battery, you are a corporate.
Yes.
We can't give you a layman that layman doesn't know. And you take 7 years.
I cannot better the case on delay.
That's all.
On the day you have presented the writ appeal,
please.
The view taken by the Karnataka High Court is that a writ appeal against a decision of the learned single judge against a Labour Court award is not maintainable.
Yes,
by choice, you prefer to go there.
Yes,
should it be put against the employee?
No, I am only indicating.
7 years is waiting and suddenly.
No, that is the end of the matter.
I am only.
Can you come to page 195?
Yes, Lord. I fully conscious.
First question is, can you come to page 195? Yes, your answers can be no or yes.
Yes, Lord.
Then go to that page.
Yes, Lord. Yes, Lord.
2006 it was decided.
I am aware. I cannot better that. I cannot better that. The only.
And if someone files writ appeal without knowing the procedure of intra-court appeal, then your client must blame itself for engaging such a counsel.
You have to take responsibility for the counsel. You
Again,
take.
but
As simple as
that, I can't better the case on that, my lord. But your lordship will only consider one aspect, my lord. The only aspect which I'm placing before your lordship, my lord, for consideration.
My brother said not on merits.
Yes, my lord, but I very well, my lord, I
we
can't.
haven't considered the matter in its entirety, especially the conduct of the petitioner in pursuing the litigation. We are not persuaded to interfere according to the petition stand. In the peculiar facts and circumstances of the present case, the petition stand dismissed. Yes, next.
Yeah, not one lordship is.
Huh?
263 days delay.
Delay condom.
One aspect, my lord.
Counsel, when the court is dismissing, you need not have to do anything. Only verify whether your appearance is entered or not.
Yes. No order.
Possibly he wants to
stand
withdraw
before.
that money.
Huh?
No,
we are not doing anything. Then we have to, that is what I said. I anticipated this from him. Since he is a young counsel, does not know, cautioning him, don't go that far. Remedies are elsewhere.
But your lordship dealing it on merits, but your lordship may leave the
merits.
Delay
condoned.
Dismissing it on merits,
No, 237 days delay condoned.
Then, my lord, your lordship may hear me on merits for a minute.
Sorry, we said in the particular facts and circumstances, will not hear you on merits.
Not delay before the High Court, delay before us.
Yes, my lord. Your lordship is delaying it. If it's dismissed on delay, then there's no difficulty. Your lordship may give me a minute on merits, my lord. Because other.
In filing the present petition, stands.
And wait.
Yes. 17.
Wait. How much delay is only in filing before your lordship?
How much?
2600 days. That delay is the only SLP delay is the only delay. There is no other.
Both on delay as well as on.
Yes.
On merits, your lordship may hear me.
Both. Sorry.
Your lordship, Lord, then it will open the floodgates, Lord, because these are all.
In the peculiar facts and circumstances of the case, yes.
Lord,
Yes.
may I also make one request, Lord?
Yes.
There is an execution petition which your lordships had stayed.
Yes.
Pursuant to a conditional order where I deposited 50% of the amount, Lord, that is due to them.
Yes.
That may be transferred to the executing court, or if your lordship deem it appropriate, may transfer to them as your lordship.
Yes, if any amount deposited by the petitioner during the pendency of the present petition, either before this court, be transferred to the executing court.
Great.
Please give the number of the executing court.
Yes, sir, I did.
Yes.
Great.
Lost. No, this is melodic.
Full stop. Counsel, we may indicate that as we at the request of our counsel for the petitioner, we make it clear. We leave the question of law.
I'm great.
Yes. Yes.
No, this Milord is an employee Milord of a private educational institution. Milord, he was terminated because he was indiscriminately Milord beating up people. The entire class Milord had filed Milord a complaint against him. An inquiry was conducted. Students were examined. Everybody, including a girl child Milord, said that he indiscriminately Milord beat him. Milord, he was terminated because of that inquiry. Milord, he files a writ petition. We take an objection that it's a private educational institution, that we receive grant in aid in respect of some employees, but not this gentleman. But the Honorable High Court does not consider it. Only says it's not considered at all, Milord. The Honorable High Court, both the Honorable judges, Milord, they note that there is a rule 12K, Milord, which provides that any employee which is engaged, Milord, in these educational institutions, before terminating, you have to take a permission. Milord, two submissions there. One,
My lord, that rule is not at all applicable to this gentleman because he is not a teacher within the meaning of the definition. Because there, the teacher is only somebody in respect of whom you are getting, my lord, the granted aid. We have, my lord, filed affidavit saying we are not getting granted aid. Question not considered. Second, in any event, my lord, your lordship in St. Mary's and Army Welfare Society, my lord, have held that wherever, my lord, even if an education, if an institution, my lord, is discharging public duties, so far as the employee-employer relation is concerned, it is always in the nature of a private character. So therefore, a writ will never be maintainable. My lord, all these arguments were placed, my lord, in the writ appeal, my lord, also we raised these. They have not at all been considered. If your lordship looks at the impugned judgment, my lord, this has not at all been considered. My lord, para 7 onwards, your lordships will find.
Is the view taken by the learned single judge?
My lord, the view taken by the learned single judge, if your lordship comes.
No, please tell us.
My lord, the learned single judge also goes into this. He says you are 100% granting aid, my lord, and therefore you are amenable to writ jurisdiction. And
what was the method of recruiting? See, we are not condoning the conduct of the respondent before us, nor will we be giving him a certificate.
Please, my lord.
We are only on the procedural deviation. If
absolutely.
Whatever may be the allegations. The order has been interfered with only because of procedural deviation.
That's
right. Correct.
That's
what is the view taken by the learned single judge?
No, the learned single judge takes a view that 12K of the rules is not followed. You have not taken permission for termination of this gentleman.
This is a protection to the employees working in a school.
Not everybody, my lord.
Let us read.
Please, my lord. If your lordship is pleased.
The rules say that they apply only to the granting aid teachers.
Lordship is absolute. If your lordship, pleases.
Can you invite our attention to the rules?
Yes, my lord. If your lordship kindly comes to page 30.
Counsel, before that, can you just tell us whether at the time of his appointment approval was taken? If he was not,
no approval was taken. In fact, there is an employee.
For rest of the teachers, you have to take approval.
Yes,
for him,
lordship is right. There was no approval taken.
There was no approval taken.
There was no approval taken. In fact, we have filed, my lord, by way of additional documents, those documents which show categorically which are the employees in respect of whom we are getting granted aid.
No. The question was
no approval was not taken.
So with regard to others, you took approval.
My lord, that I'll have to, my lord, verify.
That will be a fact.
With respect to this,
because once you commit yourself, that means it's an indication that you are amenable. Otherwise, why would you follow that approval? If it is not at that time,
there is
that time. Then
I make a categorical statement in respect of this gentleman. My lord, there was an employment contract which is there on record.
You have to show clarity that you are not discriminating. But others, you do something.
My lord, I'll file that affidavit. My lord,
that is yes.
My lord.
How do you say when you are outside? Granted aid comes for 13 teachers. If you are not in those 13 teachers, they cannot be bound for everything.
Education Act of the state.
My lord, this is, my lord, if your lordship comes to the act, my lord, that your lordship will find at page 30, the relevant act.
I am keeping in front of me page 30.
Yes, my lord.
First section itself provides for protection.
Lordship is right, my lord.
That no employee shall be removed.
That's right, my lord.
From a school except with the prior permission of the competent.
Lordship is absolutely right.
The syntax may change here and there.
Lordship is absolutely right.
Now you are introducing
a
distinction between aided and unaided.
Please, my lord.
Subject to verification, since I am not familiar with the
my lord.
Madhya Pradesh Act,
Lordship.
I may tell you, if someone is accepted as a teacher,
my lord,
you cannot also unaided teachers bring them inside and throw them out in no time.
My lord.
That's why look at the act.
My lord,
this section deals with the protection given to the employees.
My lord, definition of teacher, my lord, at page 32.
1 second, please. Teacher.
Place it.
May I read it, my lord?
Yes.
Page 32. Teacher means a teacher of an institution in respect of whose employment maintenance grant is paid by the government, state government or the IO, as the case may be, to the institutions, and includes any other teacher employed with prior approval of the authority specified by the state government in its behalf in fulfillment of the conditions of recognition, affiliation of an institution
There
or
are 6 varieties.
these, my lord.
Last but one.
My
We
lord.
come to read of this gentleman.
My lord.
Teacher means a teacher of an institution shown on the payroll of the institution against a post as being in the employment as such, but does not include a teacher whose appointment is disapproved under Class C of Section 6. Sometimes ad hoc arrangements do happen.
That's it.
Government also encourages you to do this mistake. Logic being,
Absolutely.
without paying the aid,
My lord.
you will be teaching, system will go on. To give that semblance of protection, something is provided for.
My lord.
What does the Act say about removal of teachers?
My lord, the Act, in fact, the rules say that.
That is,
Yes.
I'm sure there will be a section in Act.
Absolutely. The Lordship is absolutely right, my lord. My lord, the term protection is granted, my lord, at
On that, because that is a narrow window and also come with regard to whether what is the regulation with regard to any restrictions with regard to appointment.
What are you trying to
My lord, I have brought the rules through which, my lord, employee can be removed, my lord.
This is the one.
No, my lord, this is the Act and rules have been framed in pursuance of this.
No, first, whether you come under the purview of the Act, that
My lord,
itself is debatable.
I will, my lord, argue on
That itself is debatable.
Yes, my lord.
And then, how were you appointed? The procedure followed? Whether approval was taken by the state government?
My lord, in Act itself says that this Act has overriding effect on any contract of employment done, my lord. My lord, may see
They
the.
are not on the contract, council.
Now sit down.
Whether you come teacher under the Act or not.
Simple thing.
My lord.
You can first categorize the persons covered by the definition.
Lordship is right.
Then please go to the protection given to the teachers by the Act.
Please, my lord.
Then come to the regulation. About his conduct, we are fully with you.
Right.
The whole class is against him. We will not be imposing such a teacher on those students.
That's right.
Please prepare and come.
My lord, I file an affidavit, my lord,
Point
to-
out about 100%, my lord.
Otherwise, in 34 times.
But the state, my lord, itself in counter says it's 100% granted to the school, my lord.
Correct.
Well,
You please appreciate the distinction between aided institution and aided
Miller,
trust.
Miller,
There is the difference always.
Miller,
We want to go a step further
Miller.
and argue for you.
Miller.
You are limiting yourself to one situation.
Miller, I will come, Miller. All the.
Okay, I jointly prayed for the matter be listed when next Wednesday. Give next Wednesday.
You see, you are familiar with the AP
Give
Education Act.
after 3 weeks. Wednesday.
Not as much as your lordship.
No. Please look at the section
My lord.
and also the rule. This is the first earliest enactments in the country.
Absolutely, your lordship is right. 1985, if I'm not mistaken. 1973.
78, my lord. Act is
Yes.
78.
Yes, ma'am.
Please look at it, amendments and come back.
Please.
Yes, next.
DPO.
I seek the POSCO, my lord.
Right, please, sir.
And senior counsel is.
Driving license. See.
It's a small scope for consideration.
Please, where is the MBA Act?
Whether the 2 years would be prospective or retrospective. That is the only issue.
Yes.
They should have.
And secondly,
period of 2 years, yes.
My lord's amendment
That's
is
the
in the
point.
year 2019. The notification is in the year 2022.
Council,
What amendment?
there are two things. Enabling you to apply for the job is one thing.
Yes.
assuming that you have a valid license is another thing. That is the area of
That's
controversy.
area of controversy, absolutely.
No, we'll have to consider because they say on the date you apply, at least 2 years continuously you should be possessing it.
Yes.
Now you may have renewed, but that fiction of law will not help you because there was a break. So you are not continuously. So they have to consider that.
Secondly, no, you can also brief your advocate who will be appearing in the matter.
Yes.
Supposing you don't also take the window provided for by the Act, the consequence is you again apply for LLR, appear for test, then take the license.
Under Section 9.
Assessment.
We have question we had to consider in the MB Act. We have considered it also. I was sitting with my brother Justice Rishikesh Roy.
We have applied within time, my lords. I'll
Just
give this
Google it by referring to this section.
Yes.
You did not seek renewal within.
We applied within time, my lords.
Within time, but after lapsing, there is a limit.
No. The 30 days was replaced with 1 year. We have applied within that. I'll just show my lords.
1 year prior to lapsing.
Correct, my lords.
I
Correct.
give you one example. One has option to apply within 1 year. He is driving the vehicle and he is involved in an accident.
That's it.
What is the position?
My lords, 3 high courts have held that even
counsel is being not judgments are being to be cited. This high court has held, that high court has held.
stated that the license is valid. I'll assist your lordship.
Yes.
Even if without applying for renewal. If one has applied for renewal, it is treated. Then we have distinguished that one Madhya Pradesh judgment also. Could you get that?
Yeah.
Yes, that is the point.
Pass over.
Yes, next. Yes.
Lordship, in item 19, parties have settled the matter.
Lordships are passing out.
Just pass over, short pass over. You wanted a short pass over.
Lordship, in item 19, the matter has been settled between the parties.
Can it be taken after lunch?
Yes, put it on.
Lordship, we are seeking some time to file. Some time to file application under Article 142. Lord. The matter has already been settled between the parties. Lord.
I appeal for the protection of this matter, my lord.
Yes. Settled, matter settled?
Well, the matter is settled and we have made the payment, my lord, as per
We
the
have
settlement
received
required.
the payment.
My lord, now the respondents are required
As
to
jointly
withdraw the
paid
cases, my lord.
for filing affidavit, bringing on record the settlement between the parties, would give a date after 3 weeks.
Lord, so settlement is on
The
record.
settlement is on record, my lord. The mediation report, my lord.
Your Lordship has
Counsel, unless petition is before us, what can we
For
do?
filing further affidavit. Post after 3 weeks.
Thank you.
My lord.
Please, please to grant interim protection to us. This is regarding a bridge course to be conducted for B.Ed candidates all over the country.
Last order, my lords have already said that no positive action to be taken.
That is there with us.
Because that is there in the para
4
of the order. That order.
No, the problem is that you had to send them on a training. If you don't send them on a training, how wide should they
Exactly,
suffer?
that is what I clarified that.
Yes.
Once we notified the training period and time, the schedule, then they can take it up. It's already processed, my lord.
That is why they need to be protected because they are not willingly and on their own volition not going. You had to first notify that this is a training. Had they not participated, then only.
Absolutely.
He says, why should I suffer on the 2-year clause? You have not sent me. Okay, when do you want? So you've been doing it for quite some time.
My lords, This will be, this is already notified to the.
7-8 times the matter has been heard.
The process to be conducted.
This is what bothers us, council. When it comes to the employment of a common mind, you're not bothered. Oh, routine matter, we'll do it. Again, the secretary has no time, 2 minutes.
Last occasion,
Yes.
the NCT has already given this to the ministry. Ministry must have notified all the states. The Lalit can point out.
I appear for the state of Uttar Pradesh, which is in 3 of these petitions. I'm entering appearance. But I've just been informed by my friend here that there has been a notification issued by NIOS, which will conduct this bridge course, 6-month bridge course, and that has been after the recognition by the council, NCTE. So, let me just take a week's time to verify all those aspects, and the interim order can continue. We have no difficulty.
Absolutely.
No, but we are bothered. This is the seriousness you show.
First of August, First of August only, this letter has been issued.
No, but we have been moving from January, 8th month now. Don't dilly-dally and don't like just because it is not in the priority of the government. Then they have interim order. This is no way to reply. Then we will interfere. Let the world see that this was your. We like to incorporate everything. We're not. The life of a person doesn't run on assurances.
My lords, I appear for the state of West Bengal in item number 20.
Yes.
So the paper yesterday, they're conducting the process. The primary board.
Primary board is not a party to the writ petition. My prayer lordship may add us as a party. My instruction is after the order of your lordship on 7th of April, NCT issued a public notice on the same day. Based on that, government has issued a direction on us to give the bridge course to the deserving candidate who are covered by the order of this honorable court dated 8th of April 2024.
Exactly.
Now we are in the process of collating data from all the districts because what our previous experience is, whenever this kind of bridge courses has happened, people have
ineligible people
yes,
also get it.
That's why we are very concerned with the pre-enrollment.
Then do it.
Yes,
there has
in
to
the
be some time
on
limit.
13th of June, we have
Are
initiated
in the process. That is very difficult to digest. Are in the process of open-ended work.
Lordship, 13th of June, we have initiated the process, asked for the data.
As jointly paid by Learned Council for the respondents for taking the issue of notifying the dates for training with regard to the eligible candidates to its logical conclusion. We're putting a date after 2 months. In the meantime, if it is not notified, council, we are telling everybody, and especially NCT. NCT should also positively and proactively pursue the states. It is your job is not over, you just take out an advertisement and then. You are the controlling authority. So we make it clear that on the next day, if we find that still the authorities concerned are dilly-dallying and are casual about taking necessary steps as envisaged, as required by them, the court may have to drastically interfere in the matter. You just use a very mild word, drastically interfere. Be prepared. No further adjournment. Yes,
Lordship, kindly add the board as party in this proceedings.
Which board?
West Bengal Board of Primary Education, who have to conduct this course formally.
Paragraph.
Government has
So and so. You are Mr.
Kunal Chatterjee.
Kunal Chatterjee, Land Council, appearing for the
West Bengal Board of Primary Education.
West Bengal Board of Primary Education submits that the actual training has to be conducted by the West Bengal
under the guidance of West Bengal Board of Primary Education.
Under the guidance of West Bengal Board of Primary Education, which, if made a party, would facilitate matters.
Yes.
Acceding to the request, let so and so be made a party. Respondent number. We added a respondent number. Give the date. Okay. Amended cost title be filed. Filed amended cost title.
In the first matter, the first matter concerns
in WP number 65 be filed. Cost title will be filed within 2 days.
2 days.
By Friday. By Friday. List give a date after 2 months.
The NCT has already given this course, bridge course.
By whom? Huh?
NCT has already framed the breach cost and given it to the ministry, and now that has to be taken further by the concerned states and departments.
You are right, but then you have the power. Why don't you ask them, request them? You don't act as a bureaucratic thing. My job is done from my file, from my table I have signed. Don't have that bureaucratic approach.
Said the strict action, and also I'm just.
Yes, we will take. No. We'll clarify that. Good that you made it. You should clarify that.
We'll take care of it.
Take care of it. No ifs and buts. Especially don't try it before this court.
Union is party in this proceeding.
Practical, we want on the ground things to happen. No ifs and buts, this, that. We also know that. And we'll twist your arm so much that you'll not be able to put it right. Yes. Who is for the IAS file for impeachment and why? Who has filed IAS for impeachment?
They are similarly different people to us.
No orders. Why should we encourage now people to come off on that? IAS filed for impeachment, stand rejected. We can't open a Pandora's box. Everybody will start coming.
Because the apprehension is that everybody will be affected because the teachers who are already working and because of the.
Why they should have come? They should have come. If they want a threat, we can't give them premium.
Lordship was
Suddenly,
protected by the order of 7.
yes. Yes, next. Yes, 21. Who is preparing?
21, there is a letter
by the
respondent.
Certain circulated letter for adjournment.
Why?
We need 3 weeks additional time to file counter. They have filed additional document just 2 days ago.
Okay, as paid for by Lord Counsel for the petitioner to file respondent to file rejoinder to the
Counter affidavit.
Counter.
To file counter affidavit to the additional documents brought on record by the petitioner. List on how much? 2 weeks, 3 weeks?
3 weeks.
Your data.
I'm preparing for responding for 5 notes. I'll file my counter in 3 weeks.
Lordship,
For the first time.
after the issuance of notice. The office report indicates that certain respondents.
Wait. We have been telling you this is not a court where you can have this plea that is coming first time after notice. 15,000 cost. Look here. No, we have to make a beginning now.
Take it back.
The respondent counsel for the respondent number 5 submits that since the matter is coming for the first time after
I'm
notice.
so sorry. I take it.
So as a matter of right, he wanted time on this ground alone.
No, that is certainly not the intent.
Don't even say first and second time.
I'm so sorry.
The moment it is called, you are supposed to be prepared, counsel.
I'm so sorry. I take my words back.
Yes, next.
Lordship, I seek fresh time to take fresh steps for service upon the unserved respondent.
Why has it not been served?
Lordship,
There must be some defect. You must not have given proper address.
Therefore, I'm
Insufficient address. Yes, I knew that.
I'll seek Dusty. I'll also take Dusty in addition, Lordship.
Okay, in view of office report indicating that respondent number
3, 4, 7, and 8.
3, 4, 7, and 8 have not been served due to insufficiency of address, as paid for by Land Counsel for the petitioner. 3 weeks time is granted to ensure service through Dusty mode and thereafter file affidavit showing service. Full stop. Let's give a date after 3 weeks. In the meantime, it will be open for the respondent number 5 to place his counter on record. Yes.
I may be permitted to file a rejoinder if necessary.
We let the same be done within 2 weeks. The matter be listed. Give a date 4 weeks. 4 weeks. Time in the meantime to be utilized for filing rejoinder if any. 2 weeks you complete.
I'm so sorry.
Never do that.
I'm sorry.
You start. We've only been saying, but now we'll start. Once we start, everybody will fall in line.
Absolutely.
You take a ground before the Supreme Court, that's the first time it's coming. The council.
Lordship, item 22, we have filed a letter to file counter reply 3 weeks. I'm waiting for it.
Why?
We need to file counter, Your Lordship. We were recently engaged in.
You were engaged. Is it our problem? It will be before you and your client.
I understand.
Let us see when notice. Otherwise, we'll second of measure before vacation. The gas paid for by land counsel for the respondent by way of indulgence for filing affidavit, by way of indulgence would have to give a date after 2 weeks. Yes, next.
I'm grateful.
Yes.
Service is not complete in both the cases.
Why?
I'm for respondent number 1 in both the cases. I may be permitted to file my wakalat. For respondent number 1, very interesting question comes up in this matter. Both of you are here.
Yes.
Then we can hear straight away.
In 23 point,
I may be permitted to file my wakalat.
Why? What stopped you from filing?
I only received instructions yesterday. In one of the matters, service is incomplete on me. So after that, in the main matter, after I got...
No, once you're a party, who stops you from filing wakalatnama?
No, I got... yes, Lordship.
Why are you seeking permission from us to file wakalatnama?
No, yesterday evening only I received instructions in 23.1. Then I checked up the cost list and told them that one more matter is pending because if that service is incomplete...
They are not clear. The question was you thought permission may be granted to file. Why do you need a permission? You are a party, you've got the wakalatnama, you file it. Why should be unnecessary?
I shall file it, Lordship.
So why unnecessary when say file wakalat? You do it at your own risk. You do it at your own risk. We issued notice in April, Council. May, June, July, August, 4 months have passed. Your client should suffer. If he or she has given you wakalatnama so late, let him suffer.
In the first matter, Lordship, service is incomplete only. They were unaware about the matter also.
Yes, why service incomplete?
Lordship, in 23.1, R8, the service, it is awaited value. It is in the return.
What is the report? Insufficient.
23.1.
Addressee cannot be located unclaimed. In respect of respondent.
There in US, that's what they instruct.
And in 23.1, respondent number 8, service of the law.
So all respondents are common in all cases?
Yes.
You are then.
I'm only for respondent number 1.
In the other case, respondent.
In both the cases, respondent number 1.
In both you are appearing?
Yes.
So one is over. Now who is else?
8 and 9.
8 and 9. 8 and 9. Take steps.
She will take steps.
In the batch cases, in some case.
Evidence recorded in Malayalam?
Yes.
We will translate it.
That is the case.
On the ground, that it is a
Translation,
leading
but
question.
for local dialects important.
Interesting question both of you are presenting. Before we come to the question of law, we will have to read the evidence of.
No, we have produced in 23.1, we have produced a translated copy of evidence. Translated copy we have produced in 23.1.
Yes.
PW1 plaintiff's evidence, translated copy we have produced.
DW2 we have produced all depositions we will produce.
Don't give us Google translation.
No. It's not Google translation.
So you brought on record all translations? All translations are on record?
No, only two persons.
2 persons evidence.
Look here, at the outset, as per office report, respondents number 1, 8, and 9 appear to be unserved, full stop, in some of the cases. Some of the cases in the present batch cases, batch matters, full stop. Accordingly, learned counsel for the petitioners in the concerned cases seek for and are granted 3 weeks time to take fresh steps for ensuring service on those respondents, full stop, paragraph. However, as learned counsel for the respondent number 1 has so motu appeared in item number?
Both items, 23 and 23.1.
In both the items, no steps are required to be taken for the respondent number 1, full stop. Respondent number 1 may also file counter affidavit in the meantime. We'll give a date after 4 weeks. And yes, English, correct? translated copies of depositions of the remaining witnesses in English be brought on record by learned counsel for the petitioners, concerned petitioners.
Second, registration of a will by itself is not a circumstance to accept its execution and that it is true. We are aware of it. But here, the question put makes all the difference. Then you will have to look at your rules. I had an occasion to consider Kerala registration rules sitting with Brother Bechu.
The rule framed under the Succession Act, Indian Succession.
Yes. Please look at both the rules.
Yes.
Very interesting question.
Yes. Obliged.
Put up on Wednesday. 4 weeks after in Wednesday.
How much time will you be taking?
No, for arguments,
yes,
half an hour.
What? No, why do you think I have asked your time for anything else?
My brother said it's a pure question of law, interpretation.
Interpretation.
Why so much long? Pure questions should take. When facts are there, then it takes time. Here to there to there, jump from one A to B, B to C.
You are
it's a pure formulation.
This is only on two
slightly linked to the fact.
When my brother has formulated, then the parameters are very crystal clear.
Both of you put together 1 hour.
Obliged. Much obliged.
Yes, next.
Next. There are 3 of the last orders that have been. The counsel for the state is on his election court number 1. And the matter might go on for some time. Malus may keep it after a week.
Last one, please, similar para 3 of the last order. It is regarding premature release. You have to
He is asking for Passover. What is your request?
So he is on his legs in court 1.
What is your request?
A week's time, maybe granting.
It is regarding premature release, they have to report that, sir.
Even for reporting, you need 1 week time, or you want the council to come and tell us?
No, Malus. The council is saying that we need 1 week's time.
No, 1 week time for what? For compliance of this? You only had to come and tell us what was the position with regard to the consideration.
Well, this sentence has been suspended is what my instructions are. He's on his legs in court.
Have you read para 3 of the last order? On a query, learned counsel for the respondent state as to whether the case for remission with regard to a petition is or has been processed, he submits that if the same is not done, it will be done forthwith. Has it been processed? It's either yes or no. This much of at least instruction you should have. There's no argument here. You have to just say yes or no, whether 3, in view of 3, what is your stand? He submits that if the same is not done, it will be done. Whether it has been done or not, yes or no. So that will.
Milos may kindly pass over and seek instruction.
No, 1 second. When did he come?
When did you forward this instruction? To whom? And whether that officer has acted diligently and urgently or not? Months, counsel. So you cannot. We gave you 4 months, 8th April, and today is 6th, 5th of August, May, June, July. Exact 4 months. No, we can't say that we had given you only 1 or 2 or 3 weeks. Yes, till 2 o'clock. Come at 2 o'clock. Come at 2 o'clock. Okay. Number 2.
Please, my lord, I had to show you, lordship. The two SLPs filed here.
No, amendment or something.
Intact.
Only wanted amendment.
Amendment, yes, lord.
Has it come on record?
No, my lord, come.
How we can take it?
Yes,
like
I know.
this?
I thought your lordship will be satisfied with the orders of the court, tagging two different.
No, you may remember too many things. We remember only our ROP.
Yes, Lord. Next week, my lord, I'll file it.
Unless we amend, then only we can think whether we'll hear it or we should tag it with that.
Yes, Lord, I agree.
First, one step at a time.
Yes, Lord, I agree.
Let counsel for the petitioner, let senior counsel for the petitioner at the outset states that he has filed a petition seeking amendment of the.
Is filing, my lord.
Is filing. Yes. Will be filing petition seeking amendment in the present petition. Full filing an application seeking amendment in the present petition. Put up paragraph review thereof. This is the matter next week.
Yes,
Tuesday. Next Tuesday. Next Tuesday.
No, you don't have diary here. We used to have in the High Court.
No, here.
No, online. Online, we click, we used to come to know how many. Yes.
Next.
26.
Respondents 2 to 5 have been impleted last occasion. Notice was ordered. Is served on them. I heard from my client that they were engaging counsel.
They were engaging counsel. Yes. Who was engaging counsel?
Ultimately, they have not yet filed Wakala.
There's only one respondent, that is state of Karnataka.
No, I have filed an application for impleading and no, it was allowed.
26.
Yes, sir. Yes, sir.
26 is only one respondent.
Yes, true. The receipts payment.
Amended cost title? Did you file amended cost title?
Yes, sir.
Why? Ask the computer section courtmaster. Ask the computer section why it is not been shown on.
Physical file. Physical file.
They had to upload that. Which is page number? 35. Is part of judgment. Office report, track report.
11.2.
11.1 to 11.2. There's no 11.1 to 11.2. Huh?
If some time may be given,
Page number 12.
you would engage.
No, page number 12 is SLP. Page number 12 is SLP. Only one respondent. You can't. It is only on page number 12.
Index of contents below list of dates.
Page?
It's 80.
818.
The ACT. One.
Okay. 11.1, 11.2. Yes.
You have been served.
They have been served. No appearance. When were they served?
So 21st of April 2025.
Lord, the poor villages, Lord, why should they be talking to for engaging a council? Lord, I will ask the local police to, Lord, ensure their presence through VC before your lordships. In case any query is required to be put, Lord, why should they go into the hassle of being allowed to come here and engage councils? I'm just making a.
He's right.
You are the owner.
Lord, I was the rider of the vehicle.
So you have been now directed to pay.
Yes. Insurance company has paid them in the MEC petition. Here it's a 304. I have been convicted for 6 months, Lord.
Yes,
in that,
let's come to that.
Yes,
let's come to
some
that.
compensation I am ready to pay because he's.
Some is what? At least first we have to be justified.
Yes.
Our conscience has to be justified before we.
I have convinced them to pay 1 lakh more.
Pay 1 lakh more?
Second. For that they have to engage.
You are right.
That is exactly
1 lakh is too less. Too less. Oh, person.
There's no.
They will, you give them 500 rupees, they'll accept something is coming. So you have to make them understand that they are free. 1 lakh is we reject outright. You take instructions. Okay.
Better one undergo sentence.
It is better. Go undergo 6 months, you not be pay anything. Otherwise, our constitution doesn't permit for 1 lakh, we'll let you go.
One has to engage a lawyer here.
Why should they be unnecessarily hassled? They are not necessary.
Relatively expensive.
Okay. Though we have been informed, though the office report indicates that newly pleaded respondents number 2 to 5 stroke claimants have not been served, has been served, but there is no appearance on their behalf before the court. Full stop. Paragraph. Learned counsel for the respondent number 1, State of Karnataka, fairly submits that the claimants are poor people and maybe there is genuine difficulty for them to appear before the court, and under the circumstances, the state would discharge its obligation by reaching out to them and eliciting from their views with regard to them having any objection if the petitioner petitioner offers them commensurate compensation in lieu of him having to undergo 6 months imprisonment.
What is the sentence undergone?
No, none.
No.
0. Oh, paragraph. In view thereof, we find the suggestion to be, we appreciate such stand taken on behalf of the council, Finland Council for the state. Accordingly, the matter will issue 3 weeks. 3 weeks? Your data.
But you should come up with something so that we can put it to them, the local person can.
He is not say let not present.
Otherwise, there is no point if he's not willing to go beyond that.
Not zero. Zero cannot be there. There can be some, and then for the rest we can see. Take it more than
50-50 does not want to, you can simply undergo sentence.
So there are 4 persons, 1, 2, 3, 4, at least 52 each. That means 2. Not less than 2. You say that there is an offer 2. How much whether 2 would be okay or not?
I will put it to them. And
Put it to them.
also if your lordship would so not.
Don't say that we want. He said whether
it's okay with you.
It's okay for them, it's reasonable, then otherwise no tokenism. They know okay, you've taken, at least some money is coming. Why we are saying 2 at that level, they may be able to set up some enterprise. Something can be done. This is a decent corpus for villages, for a village family.
The reason I asked your lordship that some amount should be there, my lord, because if a police officer goes there,
Yes.
they will lose that
But
ability to
tell
say
them
no.
to go with a lady police officer and maybe not in the police dress. Not in police dress. Otherwise, they'll not be able to say no to anything. They'll just keep quiet.
Yes. We'll ensure that.
And with the PLV also.
Yes. We'll ensure how to reach them.
Yes, next. We've said 2.
I'll put it to them and I'll make them
That
ready.
means that means the scope of more. Yes, go ready, people. That means the stretching can be more.
The lordship,
so I'll make
less than that.
Because you have to understand the wrong you've done. So we may reduce from 6 months, but not 0. If it is, ask him whether even for a day he has gone or not. If he has not gone even for a day, then he has to go and taste the feel of being a government guest, state guest. So that state guest feel has to be felt by him.
I'll certainly take
it. Next.
27. Has issued notice on the question of quantum of sentences. A counter case was also registered against the company.
What is the sentence undergone?
6 years and 6 months. 7 months.
Incident happened in 1988.
Yes.
Then your age is now?
It is about 60 years. There are 4 persons of this. They were member of the same family. It is mentioned. They were.
Finally, there was death, no? 302 was also added.
Yeah, 1 person was
1
died.
person died.
4 injured men.
And,
4 injured, 1 died.
yeah. And from the accused person,
He died after 2 days.
After 2 days.
2 accused have also been got injuries, and 4 persons have been.
So what is the specific role of these 2 petitioners, or these 3 petitioners?
A specific role is against Babulal. He has been died. 4 persons have been convicted. These are 3.
Against them 3, they are only what is there has to be some role.
Yes. All they have caused injuries, but injuries were not only vital part of the disease.
Where? What do you mean by vital? Where?
Hand and the leg. 2. The leg was
and death was caused by which injury?
By the 2 injuries. The leg was cut approximately. And it was
death is because of the injury caused by you. Chopped off.
It was completely cut, man. May I read my
Chopping off of the hand.
Leg.
Leg.
It was caused by Babulal, who has been died.
That is why we said against these 3, what is the specific role?
The specific role is that they cause the injuries, but other parts of the body, minor injuries.
What other parts? Leg? You said leg.
Leg
you said
is attributed to Babulal.
against you. Where, which other part?
My lord, may kindly see page 37.
We not see, just tell us, you are here to assist us. Why should we keep on reading? What we had to read, we read it already.
This is left forearm, cut wound at bottom and front of left, inch on cut wound on right buttock. These are the deceased received only 6 injuries. 2 injuries were one was on head and right hand, and one was on leg. The doctor has also said that there was
still. They are still in custody.
Not.
Actual period?
6 years, 7 months.
Yeah.
6 years, 7 months. 6 years, 7 months. And at page 44 of the trial court judgment.
My lord, left arm was completely cut. My lord, kindly see page number 38.
Left arm was also cut.
Completely cut, my lord. Kindly see page number.
And leg was totally chopped off.
My lord, may I read, my lord, the injury part, my lord, permit me?
Yes.
My lord, page number 38, para 9, my lord. Dr. S.L. Mukherjee, PW 11, was posted as head of the Department of Jabalpur Medical College, so and so on date of injured. This is my lord, 4th, 5th line. The condition of patient was very serious. He was lying unconscious. His left arm was completely cut off. Only the skin was hanging loose. 2/3 of the hand was cut off and only the skin was attached to it. 2/3 of the left side of the leg was cut off and the muscular were also torn. The serious injury by the X was recovered from his.
Not the other person you said who died.
No, X was recovered from the petitioner.
All the petitioners, 3 petitioners, X was recovered. Babulal
by the 2 petitioners.
How do you say that Babulal was the person who inflicted that wound?
No, my lord.
There is a statement, my lord, of the injured person that Babulal had inflicted that injury on the left.
The deceased had made a statement before that?
No. Deceased, no. Other 3 persons.
She was also injured at that time. She died after 2 days. She was at that time also injured.
There is no statement of deceased, my lord. The statements.
So witnesses have stated that it was Babu Ram is saying.
No, my lord. May I read the statement of the PW?
Yes.
Let's start from page number 41, my lord, PW1. My lord, the relevant part is PW 43, page number 43, my lord. My lord, I'm sorry, page 42, my lord. Last 2-3 lines. The accused came and started beating Gullu, Himmat, Gullu, Brother Chanti, Nanne and Lakshman were also there. Who had X in their hand, he refused to beat Himmat and said the intervention was already happened yesterday. Then those people started beating him to Chanti and Lakshman. Hit with X, Gullu hit with X below the elbow of the hand. Chanti tied to X behind his back and hit below the shoulder. The petitioner handman. X was recovered from his position. Kindly see page number 57 minutes. The IU statement.
These are the simple injuries as per the doctor.
Head, left arm was completely cut off. How can you say that simple injury?
Of the deceased.
That was excessive bleeding.
Of the deceased. And kindly see, we have filed the copy of the statement of the doctor who has examined these 4 family of persons.
What?
Admission. Okay, we'll just grant leave granted.
So in the meanwhile,
No, not 6 years. No, not 6 years. Not too enough. Not now. Prayer for bail rejected.
Bail may be considered after some time.
It is for you to decide. No observation from our side. Yes, next.
Okay.
After some time, this application.
It is for you to advise your client. You know what is reasonable. Yes, next.
Please, the last day, Milos has passed the order to surrender the petitioner. We have forwarded the copy to the local council as well as structuring council minutes.
Huh?
But he is unable to contact them.
Life imprisonment, not. The exemption was granted. We cancelled it in May. Look here. Despite our order dated 28/3/2025, directing the petitioners to within 1 week, the same has not been complied with. Full stop. Having regard to the reported, who's for the state of Jharkhand?
Sorry, is it?
Who's for Jharkhand state?
No one. Let me direct the state
to the
if they can
forfeit, view of the forfeit. Let Land Council for the state of Jharkhand. No, the Director General of Police, Jharkhand is directed to ensure that the petitioners are taken into custody forthwith and produced before the trial court to be taken into judicial custody. Full stop. The same be done within 2 weeks. Compliance report be filed within 2 weeks thereafter. Let's give a date after 4 weeks. Paragraph. Registry shall serve a copy of this order to donate. Click here. Despite service of notice, there is no representation as there is no representation on behalf of the respondent state of Jharkhand. Let registry communicate this order directly to the Director General of Police, Jharkhand, forthwith. Yes, next.
But I'm for the Karnataka Lokayukta respondent. We are seeking some 4 weeks time to file a reply in this matter, some documents.
You already got time. 4 months time you got. April.
But there was
notice
some
in
issue
April.
with respect to the representation.
What representation? What representation?
Lord, earlier, Lord, the state was represented separately. The state was representing the Lokayukta group. Now the Lokayukta has taken up separate representation before the state. So we seek some time to file our reply.
Okay, as paid for Land Council for the. But have you been made a separate party?
No, my lord. This was a prosecution by the Lokayukta.
No, but it's only state party.
By law.
It is only state represented by the inspector.
State by the inspector of Lokayukta. That it should perhaps have been.
By the respondent. Respondent will say? By the respondent for filing counter affidavit. The Land Council for the, at the outset, Land Council for the respondent number 1. Submit place for further time to file counter affidavit. Accordingly, as paid for list after 4 weeks.
4 weeks. Interim order to.
Interim order to continue. Publish.
Seniority. In the lordships in this letter.
see the other side may be bearing because I had served the copy to the Standing Council of the State of Assam. So, Your Lordships, this was a case in which what we had principally stated.
They served the copy.
Yes.
To whom?
To the Standing Council for the State of Assam.
Whom?
I had done it to Mr. Ankit Roy, and then we had got the message today from him that some Mr. Subhati Roy will appear in the matter. That's what has been intimated to us.
When did you serve it on him?
It was served on 16th of July and the proof of service was also filed.
Okay.
Is it coming now?
I think this is for
Why is it coming now?
After conviction.
The matter is coming up because it was to be decided. There was a very short point that at page 102, it was.
No, it is coming only for appeal against rejection of for conviction, upholding of conviction.
No, it is coming for the reason that I had challenged the entire matter. Then thereafter, Your Lordships had held on 2nd of May 2025 that issue notice on quantum of sentence in view of the provisions of the POSCO, especially section 4 thereof, because what had happened was that this was an offence which was committed prior to the date and the old enactment was to apply because there was an amendment in section 4 of the POSCO Act. As per section 4 of POSCO Act, which existed prior to the commission of this offence and which was at the stage when the offence was committed, at that stage section 4 was applicable. It stated that the minimum sentence is of 7 years. Now the district judge had very categorically noted at page 102, that is para 72, considering the facts in hand, I am of the opinion that it is not a case of awarding maximum punishment. The minimum punishment as provided by law will meet the ends of justice. Accordingly, convicts Umakanta and Basanta are liable to be awarded the minimum sentence of imprisonment. This order was confirmed by the High Court thereafter. So my respectful submission is that when the minimum sentence as on the date.
So you wanted to only 7 years?
Yes, if at all. No, because Your Lordships, I had challenged the larger issue. No, but Your Lordships, just tell me.
Sentence does not mean minimum sentence.
Your Lordships, they said this was an order, this was a direction by the district judge at Assam. I had challenged the entire action. Your Lordships, if I may just show, page.
That is why we wanted the state, because it is an interpretation of the.
Yes, because Your Lordships, even page 16, that's the impugned order very categorically says that this is prior to the amendment.
I read the evidence. I read the statement under 164.
Then Your Lordships, I could have argued the entire substance, but since it had fell from Your Lordships, when I had indicated to Your Lordships at that stage.
Are you suggesting it should only be 7 years?
Your Lordships.
Please say yes or no.
Yes. That's what I'm saying, Your Lordships.
Sorry.
Why? How can
Your Lordships, I'll just show. Your Lordships may first see page 16, para 14.
That argument I understand, madam. It does not take much time to follow.
Just take the, Your Lordships, para 34 first, page 16. In conspectus of the aforesaid discussion and material on record, we are of the view that the conclusion arrived at by the learned special judge Jorhat Assam in convicting the appellant in special case number dash, Friday judgment dated 23/2/23 does not warrant any interference and both the appeals are dismissed. Though the offence of a date prior to the amendment of POSCO Act, the punishment imposed is in conformity with the provision with the existing Act and does not require any reconsideration. Now, my respectful submission is that when the matter was decided before the district judge, he had stated that I'm awarding you the minimum sentence.
Where is it?
Your Lordship, this is page 102. Yes, Your Lordships may just see. First of all, para 72, considering the facts of the case in hand, I am of the opinion that it is not a case for awarding maximum punishment. The minimum punishment as provided by law will meet the ends of justice. And then they said, which is 20 years. But 20 years was not there in August of 2019. That's my case.
That's a simple point we have understood. You're laying much emphasis, really straining too much also. Not needed.
But Your Lordships, all I'm saying is...
One second, not needed. Simple is, if it is to be minimum, fine. If it is sentence, what should be the sentence is the next question.
Yes.
If you say punishment in a case like this meets the ends of justice by imposing 7 years, sorry, I have different interpretation for it. I will immediately answer you.
Your Lordships.
Let us wait for the state. Because once we have gone past the state, let them also take a stand, because for them also it will be,
very well.
They'll have to.
If you say, though it is minimum, reasonable sentence means we may hear you.
Yes.
If you emphatically say that, look at the minimum, substitute the standard means we are not going to do.
Your Lordships, I stand corrected and I say that because it has to be dealt with.
I read twice 164 statement. Earliest statement recorded before the magistrate.
Let the other side also come, and then Your Lordships, as far as on this point is concerned, I'll request Your Lordships.
Now you are on the point.
Your Lordships, I apologize.
No, much strain is not needed. Let other side come.
Okay,
Very much obliged, Your Lordship.
On 15/7/2025, we had directed Learned Counsel for the petitioner to serve the standing counsel for the state of Assam as for the reason that
Yes, sir. You could be revived for the simple.
Did you, after serving, did you inform the registry that the name could appear?
Your Lordship, as far as the proof of services concerned, it was uploaded thereafter. We had uploaded the proof of service.
Uploaded?
Yes.
Let us.
It is also recorded in the document.
Let counsel submit that such service was effected on 16th of July 2025 itself, and proof of service was uploaded on the Supreme Court website. Full stop. However, we find that name of learned counsel is not appearing. Full stop. Learned counsel for the petitioner submitted that he also personally talked to the learned standing counsel and was informed that another counsel would be entering appearance in the present case. Full stop. However, the same has also not been done. Full stop. Be that as it may, comma, by way of last indulgence, comma. Further 2 weeks' time is granted for the state of Assam to file a counter affidavit, stroke, come up with full instructions in the matter. Either file counter or come up with full instructions in the matter. Full stop, paragraph, list on, give a date after 3 weeks. And name of which counsel was to appear?
It is Shubhadeep Roy.
Just give it, Shubhadeep.
I defected service.
Be reflected.
It mentioned Shubhadeep Roy.
Reflected in the call list.
Madam, when court directs, it comes.
We are directing that.
We direct, it comes. You please write, let such an objection come from registry, I will deal with it.
Registry to reflect the name of the standing counsel, will reflect the name of, because
Mr. Ankit Roy was the standing counsel to whom we had.
Ankit Roy, whose service has been uploaded on the Supreme Court website. But then why did you not do it if it is uploaded on the website? Supreme Court? Standing counsel?
Proof of service has been filed by the counsel for the petitioner. So that has been.
Agreed. Sometimes we would like to hear the respondents. Then we say
Without-
print the name of so and so. Registry can't say that we will not print their name in the cause list. Yes.
That, yes, print that name. Yes, next. Okay. Yes, we'll come after lunch. We'll come after lunch.
Basic lots of agents mention out of turn lot. Because grave urgency up to 50 lot. The bailiff has reached the spot lot and he's evicting the petitioner lot. That's so lot. I'm missing out of turn lot because normally I don't do this lot. Just I received a message from local constable lot.
So what is the matter about?
The matter is about lot the eviction petition is pending lot and the bailiff was appointed lot for 7th of August lot. Now the bailiff has just reached the spot lot and he evicted the petitioner.
Today is only 5th.
Pardon?
Today is only 5th.
Yes, Lord. Warrant of position was returned on 7th. So bailiff has reached the spot. That's why I never do this, Lord. I do 15, Lord.
Yeah, 15 number. Come at 2 o'clock, 2 o'clock 50. Come with the other side. At
I will inform you.
We'll come at 2 o'clock.
I'm so grateful.
Item 50.
The sole question of formulating this matter is that.
Did you ask the other side? I told you to get.
Yes, sir.
Where is he?
Other side, Lord, the council is informed that since the bailiff, the decree holder has taken position, already taken by the.
Mr. Counsel, we asked you to tell him to be here.
Yes, the council with the private respondent, Lord. I have
Yes.
asked the council Ashok Sehgal. Lord, he has informed that now since the position of the has been taken by the bailiff, so I have no authority to join the proceedings. I have WhatsApp, Lord. I will never make a false plea, Lord.
So what is the position?
So we not that
bailiff has technically sealed them.
Yes, the bailiff has transformed the articles out, and he's lying on the road. As of today.
No.
What is the order you are challenging in the SLB?
The SLB will not in this order will not. I have gone to the Honorable High Court, Lord, against the order of eviction passed against me, Lord.
What is the ground for eviction?
Since that on the ground that since the respondents have already been divested of all the rights, Lord, because their allotment has been cancelled, Lord. So they have no right to get.
From whom have you taken possession?
From Gurcharan Singh, Lord.
From
Gurcharan
Singh.
Yes, Lord.
What does the law say?
Pardon, Lord?
What does the law say?
The law, the clause 11 of the allotment says that he cannot sublet the premises, Lord, to anyone.
So you are a trespasser in that.
Taking possession, you deny the very authority of the person.
Lord, what I am submitting this, Lord, this shop is the only source of livelihood, Lord. I am in the position of since last 14 years, Lord, and I have 2 kids, Lord.
Does not mean that you should perpetually remain there.
I am not saying so, Lord. I go around. What I am saying this, Lord. The person, Lord, who has no right to title to the property, Lord, how he can initiate any eviction proceedings against me, Lord?
Counsel, but did we had not ordered that? We are only ordered for listing.
Yes, Lord.
We have not passed any order.
This is the
you should have assisted us that the returnable date was, so we could have, normally we do that, we go out of the way to accommodate. But here, now come on merits, we'll
that's why, Lord, what I am saying, Lord, once the allotment has been cancelled, which has been granted for the respondents, the petitioner interest, Lord, then how this person can file a eviction petition against me and get me evicted? This is a pure question.
No. It is not as his instance you are evicted. You are evicted because the Chandigarh Municipal Corporation has evicted you. Eviction is by whom?
By eviction petition filed by Gurcharan Singh, Lord. Kindly seek the order.
So bailiff has handed over question to Gurcharan Singh?
To his son, Maninder. I'm having,
Then we'll have to hear both of them.
Also, there is an order of the High Court that even if there is eviction, you cannot hand over the question to Maninder.
Have you made the Chandigarh Municipal Corporation a party?
Where
is it a party? Chief Administrator? No, not Chief Administrator.
He was not party, I admitted party.
No. Actually, the shop belongs to whom?
The Chandigarh Administration.
Administration or Municipal Corporation?
Municipal Corporation. Estate officer. Estate officer.
Because the matter was taken out of turn today on mentioning been made in the past by Learned Counsel for the petitioner that the bailiff was in the process of evicting him from the premises in question. Full stop. However, we have been informed that the bailiff has already got the premises vacated and has handed it over to the respondent number. Which respondent?
Respondent
one.
Respondent
number 1. Full stop. a paragraph having regard to the nature of the dispute. Let learned counsel for the petitioner plead the Chandigarh Municipal Corporation as respondent number 5. Let necessary correction be made in the cause title by filing let amended cause title be filed by tomorrow by learned counsel for the petitioner. Full stop. Issue notice to the respondents, all the respondents. Urgent notice to all the respondents. In addition, learned counsel for the petitioner is permitted to serve Dasti also and file affidavit showing proof of service. Let the same be done within 1 week. The matter be listed, give a date after 3 weeks. Come.
51 is a fresh bail ban.
Well, take up. Let us finish first.
I'm grateful. Your position may be restored to the petitioner. Position may be restored to the petitioner.
How can we do that? How can we turn the clock back?
I'm so good.
Can it be done ex parte?
It's very good.
And to whom? All that issues that we gone into.
I'm so good.
Yes.
Malas item 51 is a fresh matter. Malas there is 2 FIRs registered. Malas as the FIR was same date, same time against each other. Malas is cross FIRs. But trial of both FIRs in different courts. One is an additional surgeon judge and other is a ACGM first matters. I have filed and transfer application for clubbing of both trials.
Issue notice. In the meantime, proceedings in both the cases shall remain straight.
Much obliged.
Give the details of both the cases.
Yes, madam. I just much obliged. Okay.
List. Give a date after 4 weeks.
Yes, madam.
I'm going to give the details of both.
Yes, madam. I'm just writing down.
Write it down.
Much obliged.
Or is it in your prayer? Prayer portion?
It is my prayer matters also.
One will be there.
Madam, the prayer is at page number 14. In the grant ex parte identity of the session trial number 942 of 2022 arising out of from the FIR number 280 of 2019 under section so and so.
Both.
I'll just give both. Writing much obliged. I'm grateful.
Please, Lordship, I appear for the state in this matter. As for my instructions, he's been considered for remission, but no decision has been taken by the advisory board since he's already on bail. The Lordship may direct the advisory board may take a decision within a period of 2 weeks.
It is you, state. Advisory board is your board. Why are we doing like this? We were assured on the last occasion. Read that order.
Lordship, so as for the last order, he was released on suspension of sentence. He was released on bail. Subsequently, there was already a proposal for him to be accepted on remission, but the advisory board hasn't taken a decision because he's already released on bail.
Please, have you taken complete instructions from the advocate who appeared?
Lordship, I've taken oral instructions.
The advocate who appeared in the matter?
Lordship's personal pick again is in. If your Lordship may grant me a week's time, I'll find an affidavit as per.
Not correct, counsel. We just wanted to know when was this order copy received by your office? When was it communicated? To whom it was communicated? What is the response received from him? We wanted him to get instructions on that. Now he sends you without even informing what are all the questions put by the court.
I was present in the last occasion when the
Read para 3 of the order. Read aloud.
In the foreman, were you present?
Yes, Your Lordship. As per the remission.
No, not on the foreman, you are not present.
On query to the Learned Counsel for Respondent State as to whether the case for remission with regard to petitioner is or has been processed, he submits that if the same is not done, it will be done forthwith.
So, why has it not been done? 4 months have elapsed. Exact 4 months have elapsed. Why has it not been done?
Lordship, he's been recommended for remission.
So we are going, you the state will now represent one authority. We are representing only recommending authority. The advisory board is not state.
No, Lordship, I don't wish to submit that. Your Lordship, in 2 weeks' time, I'll press upon the state to consider this and to pass an order within 2 weeks' time. Your Lordships may pass a direction also to pass the order within 2 weeks' time. So that
We'll impose cost. We are
Lordships
not here to repeat our direction. It is violation, then we hold them up on the violation.
he's been released on bail
Okay.
already. It's only the issue of remission.
That is not an issue before us. We had directed you to consider remission. Whether he released on bail, not released on bail.
Your Lordships may grant us last indulgence for 2 weeks. Your Lordships will have the order passed.
What is the instructions?
Lordship, as per my instructions, there's no decision. So he's been recommended for remission, but there's no order passed.
When was he recommended?
Lordship, I'll have to, if you allow me to file an affidavit to this effect, I can have it filed by Monday also, Your Lordships.
Come at 3 o'clock with this. Otherwise, you know what's coming your way. Come at 3. Home fellow.
You are leaving to us two options. Exemplary cause or
Contempt.
ensure the presence of respondents for proceeding further as.
Lordship may grant us the last indulgence, we'll have the order.
Come at 3. Call next.
Lordships, we have circulated a letter, Lordships, 4 weeks time to file counter.
Huh?
4 weeks time to file counter, Your Lordships.
Why again time?
We have circulated a letter, Your Lordships.
So why should we grant you more time? After 4 months it's coming, and why again should we grant you time? Why? What is justification?
Lordships, please
For grant.
give us the last opportunity, Lordships. We'll file it within.
Then we impose cost. Why should we make a difference in you? 4 months, then you don't file. You need extra time. That means you don't care about the orders of this court. 4 months is insufficient time to file.
Apologies, Your Lordship, but we'll file it in 2 weeks time.
You file it, you don't file it, we'll impose cost. We'll give you a short date and then you know what's coming. Okay. Today, Lord Counsel for the respondent state
Yes, Your Lord.
State of Tamil Nadu makes a prayer seeking further time to file counter affidavit. When did you receive notice? What must have been notice out?
12th of July.
12th of July. Oh, then it is. 6 type. Nay, as paid for Lord Counsel for the state to file counter affidavit placed after your date after 4 weeks. Yes. In both the matters. 31, there are 2 matters. Both the matters.
Both the matters, Your Lord.
Yes.
Petition.
Yes, make a submission. Who's stopping you? Make a submission.
Yes, as per the last order, my lord, has directed the state government to take the instruction by 6 May, my lord, passing direction.
On the last occasion,
Yes, Mr. Raj.
yes, I sought instructions from the government. I just want to place what I have got in this.
Yes.
What the state is already doing and what more needs to be done. Can I just pass?
No, give a brief, concise of
Yes, as of now, to take care of people like the petitioner, state government is giving on its own 2,000 rupees per month. Now, if something more has to be done, because otherwise they don't meet the cutoff date, these are minutes partly funded by the center, 60% central, 40% by the state, both the noon meal scheme and the ICDS scheme. So the financial implications are huge, in the region of about 3,500 crores, considering the number of retirees. In which case, my instructions are, we need some more time to consult the central government also. Either my friend can plead the central government, or of course, we will take it up with the central government and come back. But it's not that they are not being given any relief at all. State government on its own is giving 2,000 per month as a form of ex gratia, since they don't qualify otherwise.
As per your obligation to pay 40%.
Lordship, please.
So you're giving 2,000.
No, this will not correspond exactly to that. Perhaps not.
No, but it will be part of that.
Lordship.
Ultimately, it has to be
Lordship
in that ratio.
Lordship, please.
4:6.
Lordship, please.
Or 2:3.
Lordship, please.
But why is center not contributing?
No, it will not.
Since
it's a program. Over.
No, it was with regard to like there was like census. Census also happened and it was for a particular time. Everybody comes for that period, 2-3 years, and goes away. Was this also under some program?
This was, of course, noon meal scheme, the ICDS, Anganwadi workers.
No, is it still continuing or that scheme is over?
No, these are continuing. These are continuing. These are persons who have retired.
No.
Then,
is it continuing as per the original center state partnership?
Yes.
Still on the same term?
Still on the same term. Because these are welfare programs.
No, but why has the center not contributed and what is the controversy?
The controversy is something different, Millards, that the state government decided to make some people eligible for pension. That is, those who have got absorbed prior to 2003. After 2003 comes contributory pension scheme. So then that question doesn't arise. This is a category of employees who, Millards, were not absorbed prior to 2003 and have just served for a few years after the contributory pension scheme has come into force, maybe 4 or 5 years, and then they have retired. Now, this is not a kind of case where casual labor is absorbed. Those who have been absorbed, Millards, prior to 2003 have been absorbed after tests in other posts like teachers, etc. So these people, Millards, there has to be some cutoff date there.
No, then you are paying 2,000 by way of pensionary benefit.
By way of pensionary benefit, but still in a kind of an ex gratia form, let's say, without reference to their qualifying service, etc.
No, we'll have to hear because he has made a point which needs consideration by us. So in the interregnum, if they are paying you upfront 2,000, I think we can't say it to be totally arbitrary or unreasonable. And at least because finances are basically to be gone into based on what are the actuals. We cannot really, and this is something because you had no right in the beginning. It was only a scheme. Some were given the benefit on a very, very sound distinction that whoever were absorbed prior to the cutoff with regard to pension, they have been granted the benefit. After that, uniformly, every sitting serving state employee is also covered by that. So why for a person who was totally in a limited period or not on a government job post, why should he be given an extra benefit which is not available to the state government, direct state government employees? And you knew your service conditions when you joined this scheme. It was totally a scheme unconnected with government service. How can we really interfere in this council? It is like we are substituting our view with regard to you being granted some subsistence allowance, if you can say that, by way of pensionary benefits. Anyway, you want some time to...
If something more can be done, that's all. So
no, but
I've stated the position.
By when can you take a firm and complete stand? So that
the request of the state is 3 months. The request of the state is 3 months.
We'll grant that because okay. At the outset, Mr. Raju Ramachandran at Senior Counsel for the state of Tamil Nadu submits that they have looked into the matter sympathetically and on humanitarian consideration with regard to the petitioner and similarly situated persons. For the time being, an amount of rupees 2,000 per month has been directed to be paid to all of them. Full stop. It is submitted that though strictly speaking in law, they may not be entitled to any such benefit which they seek in the present petition, but in the larger public interest and the state being a welfare state, such decision has been taken by the state government. Full stop. Moreover, it is pointed out that the scheme under which they were appointed and the scheme which is still continuing clearly stipulates that the persons associated with it will not be government servant, and they were only they are only engaged for the purposes of giving effect to the scheme, which is the midday
meal scheme and
midday meal scheme,
noon scheme,
midday
noon meals.
noon meal scheme sponsored by the central government. Also, further, the stand is that under the said scheme, even the payment of honorarium, so consolidated amount per month was in the ratio of 60% is to 40% by the center and the state respectively. And the present rupees 2,000 is being thought to be given purely from the state fund. Full stop. The council submitted that under the said background, comma, the state may be given one more opportunity to again revisit the matter and take a final stand with regard to what maximum accommodation it can do with regard to the cause espoused in the present petition. Full stop. Paragraph in view of the aforesaid as paid for post after 3 months. Exactly. Especially in view of the fact that such type of financial burden, not only being huge, comma, will have a cascading effect where other such similarly situated sections would also start raising their claim on the basis of parity. And then you come, give a date after 3 months.
Great. Totally.
It's a motor vehicle accident case, my lords, wherein the mason was working. He lost.
Speak up, you haven't had lunch or what?
Sorry, my lords. My lords, the 37-year-old person got injured and lost his 2 legs, my lords. One is right leg.
Lost his 2 legs. Did he have a 3rd leg also?
All the,
lost
right,
2 legs.
Right leg amputated, my lords, and left leg also below the knee, and the one leg is above the.
Come to the point. What is your claim?
My lords, my claim is, my lords, it's a year of 2016 accident, my lords.
You have got 43 lakhs with 6% interest.
Yes, my lords.
From 2016.
Yes, my lords.
What more do you want, counsel?
My lords, kindly see, my lords, the High Court.
What was your age?
The age is 36, my lords.
So?
37 years.
38.
37.
Somewhere I read 38.
It was 38.
38 and now add another 4, 5, 9 years.
30 years old. 30 years old. My lords, there are the same circumstances.
So now they are very good mobile. You see, every day you'll find automated mobile, even if you can't walk.
Yeah,
people with both legs amputated also have prosthetics. They even take part in marathons and races.
Yes, my lords. In a same kind of situation, my lords have awarded in one case, my lords, wherein, my lords, that they calculated for this artificial limb and also with 30.
Now, sir, this is the most commonly freely distributed thing.
Yes.
For disability. Artificial limb is the most freely and commonly.
Yes, my lords, it starts from 55 to 25 lakhs. What the High Court was. It's depend upon material. It will cost, my lords. Here, then my lords have taken a liberal view.
How much? It will cost 50 lakhs for those legs?
24 lakhs. Up to 24 lakhs will get a good quality. Here, it will only be taken is only for 55,000 something else. The meager one. It's okay, but in the same situation, my lords have taken.
Don't tell us, both of us have held position in the legal authorities. We know.
My lords, even the.
Don't sound.
My lords, just I'm relying on judgment of this honorable.
You can make it for platinum,
yes.
Gold also.
No, my lords.
Diamonds also in
my
that.
submission is, my lords, it is there, but my lords, I'll leave it to you, my lords. I am not.
Leave it for us. We say it is highly sufficient.
But my lords have taken
almost 10 as 60% add to that. 6 4 that 24. Another 24 lakhs to that. 42 plus 24.
Yes.
Is it how much? 66 lakhs. Council. Without income tax. 66 lakhs. Lump sum you get.
Just I would like to show the judgment, my lords, where it, my lords, legally consider for this kind of the experiment, my lords. So 37-year-old, my lords, have considered 7,80,000 and 5 lakhs was given to the future.
You are saying 40 lakhs, 55 lakhs.
And that's what are my
5 lakhs, 7 lakhs, yes, it is reasonable. Okay, 5 lakhs, 7 lakhs.
Yes, my lords, I am just.
So how much has been given by the High Court?
Here, my lords have given High Court 43 lakhs. Altogether,
that has to ask 6 to 7 lakhs.
The medical expenses, it comes to my lords only 9 lakhs 50 to my lords. And I myself for the state of 4 lakhs
have already been given.
Yes,
come on.
Total amount it will come to together, it will come like that, my lords. Even if you see, my lords, High Court has reduced it in so heads, my lords. That's on page number.
What head? What head did you tell us?
That's a page number, my lords.
No, don't be page number. Tell us.
Page number 13.
We prepared a chart.
Yes, but page number 13.
No, we don't. But we prepared a chart to tell us the amount. Which amount by the MACT? How much is it?
MACT, my lords, as concerned to the future loss of income, my lords, MACT is getting 14 lakhs 40,000, my lords. High Court increased to 23 lakhs 94 because future.
You said High Court has reduced. Where is the reduction?
That's the next one, my lords.
Yes.
Next one, pain and suffering, my lords.
1 lakh 50,000. Everything has been increased.
And next, my lords, next is same line, my lords, and food and attendant and transportation charges, my lords.
Yes.
The tribunal was granted 14, High Court was increased to 1 lakh, my lords. And
you're asking, you said High Court has reduced. Every column you're showing is increased.
My lords, my humble submission is, my lord, that as concerned to the income of the person was taken very lower side, my lord. That is, my lords, only 9,500, my lords. It's a 2016 accident, my lords. Well, altogether,
in this case, the council is so vehemently arguing, we have a doubt whether the client has to pay on percentage basis or what. Otherwise, for how much of a spirited council for a 2 lakhs. Now you get 68 lakhs, 66% for 10 years, 24 lakhs.
That's true, my lords. But look into these.
If it's true, then what is
he lost entire life, my lords, in the last.
No, we'll give him 2 crores. It is our fund. Yes. Now every MSCD matter 2 crores.
Is my just I mean just my what my lords have said in earlier, just on the basis of my.
Are we bound? Are we not entitled to also mature to understand the factual position?
I don't know.
Bound that I'm sorry, especially with regard to compensation.
No.
Totally.
My lords have
perception. It is total perception.
For this,
there cannot be any quantification of disease, death, injury.
Yes, my lord.
Totally perception and the circumstances.
Yes, my lord. And I'm aware of that, my lords. My lords are very kind in these cases, but just.
Anyway, not a case for so much of indulgence.
Yes.
Be satisfied. Don't give any false hope.
My lords, because my lords, the future expenses will be in very higher side for this. So if you take it in a 17 years, my lord.
6 lakhs. And when you get a composite amount, it is for everything. In that, you don't have to say, okay, I cannot spend more than 6 lakhs from this because the High Court has granted me 6 lakhs. It is not like that. Somewhere it is flexibility. An amount is there. This is only for the purposes of arriving at a formula for quantifying. Yes.
True, madam.
Just compensation to arrive at. We make it into subheads so that it is more justifiable and then a quantum can be arrived. Otherwise, what quantum? There has to be some basis for that. Only for that purpose.
Well, the finding of both the courts is the plea you have set up failed to establish. Still, courts have treated you as assuming that he cannot do that. Still, it can be said that what is that HCL tariff that has been applied.
True, madam.
Future prospects also taken care.
Taken care.
And 1/3 alone is deducted.
Yes, madam. I'll leave it to you, my lord. That's what I have for my lord.
And 40% has been the enhancement.
Yes, sir. Future prospectus. So earlier the tribunal was not taken the future prospectus.
That has also been given.
Okay. I'll leave it to you, my lord.
Having considered the matter in its entirety and having considered the matter in its entirety, especially the nature of injury suffered and the amount awarded, in our considered opinion, without adverting to the headwise calculation made by the High Court, we are satisfied that the overall amount is justified in the present case. is just compensation in the particular facts and circumstances of the present case. Accordingly, the petition stand disposed of.
Highly.
Yes, next slide.
Please, my lords, I will file my memo. I came to know morning this matter, my lords.
You came to know?
This matter, about this matter, morning only, sir.
What do you want then?
I will file my memo, Bakalat, my lords.
You filed, you will file.
Yes, I will file today.
But why you taking so long?
I was told that it has been given to some other aspirant advocate and record.
As paid for by Lord Counsel for the respondent number 1.
1 and 2, my lords. Both.
For the respondents for filing Wakalatnama and also counter affidavit. List after a list on, give it 4 weeks. So give a date of 4 weeks.
Right.
Please, it's been over 6 years since the day he made an offer before the Honorable Court. Till date, nothing has been paid, my lord. In fact,
what is the matter about?
Maintenance regularly.
Yes, who's appearing for the other side?
No, and my lord, in the last occasion also, my lord had observed, the London Registrar has observed that despite service, nobody has put in any appearance. And that is why the matter was posted before this Honorable Court. And despite having offered, my lord, in the lower court in the...
No, but counsel, our last 3 orders say as paid for by Lord Counsel for the petitioner on personal ground. Yes, yes. On your ground, last 3 times adjournment has been taken.
It was because of my eye surgery, my lord, I had already.
So that is why I say the last 3 occasions you were not present.
Appreciate, my lord. But somebody from my side, we have been asked requesting. It was only because my surgery was...
When?
But as far as the order of the London Registrar...
But counsel, the only trouble is that if you pass an order, for implementing it, you'll another take 2 years, 3 years, then you'll be harassed.
Appreciate, ma'am.
So that is why our endeavor always in such matters is that the person is here so that we can bind him down.
I understand.
So what do you propose?
He was bound by the order.
No, but what do you propose? Can you serve Dasti?
We can serve it in the court where he is appearing actually. He has been appearing. There are litigation which is pending.
As in view of the fact that despite service of notice to the respondent in the year 2022 itself, there has been no representation on his behalf. Full stop. Since in view of the fact that the respondent would be required to be present before taking a final view in the matter, Lord Counsel for the petitioner volunteers to make one further, is volunteered to serve the respondent afresh through the counsel who is appearing for him in the court below.
Please, I am with you.
Full stop. Having regard to the aforesaid, let the same be done within 3 weeks. An affidavit filed. Let's give a date after 4 weeks. Do it in 3 weeks. File affidavit within 1 week. It will come after 4 weeks.
Okay. I'm with you.
6.
There is 36.
I'm for respondent number 2. See, Arvind Council has circulated a letter for them.
Why time?
Because he is in Medanta hospital on account of surgery.
As paid for on behalf of Land Council for the which respondent?
Respondent number 2.
Respondent number 2, list. Give it at 4 weeks.
Okay.
Yes. Yes.
Lord, this is a case where whether the petitioner is entitled for a retrospective regularization with effect from the date of initial appointment as estate clerks and consequential refixation of pay and pensionary.
No. There are 2 things. Can we proceed on the presumption that he is covered by the Supreme Court order which directed for framing of the scheme, he is covered.
Yes.
Second point, the specific direction of the Supreme Court was frame a scheme within 6 months. Together, ad item?
Done.
Now, when was the scheme framed?
1999. Well, I have the
No,
list.
just a minute. No. When, date. When was the scheme framed? Pursuant to the Supreme Court direction 27/8/1999.
So, according to my instructions are that this judgment was in 1999, pursuant to which scheme was framed, and from 2000 till 2000.
We are not on. We want exact dates.
I can get.
That is the crux. Because the Supreme Court stated that if the scheme is not framed within 6 months, the High Court order will revive. So even if it is 1 day beyond, then they get everything. So that date is very important when you frame the scheme. Because you never challenged, you never sought extension of time.
Malaj, the benefits of the scheme, Malaj, it's from
It continued for a long time. We are asking you the scheme because there was an alternative. If it is not done within 6 months, the High Court order will revive. That means all back wages, everything consequences. Everything hinges on that.
I have one submission to make
Yes,
here.
yes.
My list of dates, if Malaj can just have it.
Nothing, we don't even need it. We only need to be informed.
Then. Malaj, I will give the dates then. Malaj, pursuant to this, from 2000 till 2010, they were all absorbed.
We are not on the absorption council.
Put it also.
The only difficulty is whether they get back wages. So if the High Court order...
Retired, Malaj, long back. For the first time in 2018, they filed this OA.
They may file it in 2035. We are not on that.
Malaj, they filed the OA not saying that the scheme was related or anything. They said that there is another judgment because these people, they were pleaded in the matter which was there.
Have we asked you to reply what are the amendments made and the stand taken by the
Malaj,
petitioner?
Malaj, I understand Malaj are asking me about the date of the scheme. For that, I have to seek instructions. I'll come back with the instructions because
I don't know why you take half-hearted. It starts with framing a scheme, implementing it. The first thing is, yes, pursuant to this, we complied with this. This is if I were the advocate, the first thing would strike to me as a common advocate looking at the SLP is this only question, the first question. I don't know how when we ask the basic question, counsel said, for that I will have to. I'm surprised in this case. The starting point is the Supreme Court order.
According to me, coming from the record, it is 27/8/1999, but I can produce the scheme.
That is the order of the government of the Supreme Court. We are asking you when did you come with the scheme?
I'll file the scheme.
Okay, at the outset, as paid for and counsel for the state to come with specific dates in relation to the directions given by the Supreme Court earlier in the earlier round, as well as by the various high courts. Put up next Tuesday. Call next.
Please.
You should also have come, counsel. It is your case and you are silent on that. You wake up from a slumber after 10 years after retirement. And you also don't have these basics and you're fighting till the Supreme Court. This shows the casualness of your client.
My lords, I was implemented in 1998 before this Honorable Court, my lords, by an IA.
That is why you are covered by the Supreme Court order. Please. So now it's not your duty to say that, look here, I was covered because this has what has been not been done. So now I have to get the benefit, fait accompli. Is that not your starting point?
My lords, I go down, my lords. They wanted.
No, you don't have to go down. Just realize after everything, waste your time again from the basics. No answer. Flat. Both sides. Yes, call next.
Pleasure.
Please, sir.
Yes.
Lordship, in item number 38, victim was young boy of 22 years who completed MBA. Accident occurred, his death was done at that time. And the tribunal has calculated his income, 40,000, but not calculated his future income, everything. So I have mentioned everything in para number L, Lordship.
No, at that time he was a student.
Student.
So there cannot be income.
He completed his MBA.
But he was not earning. At that time there was no income. It was only future prospects only.
Lordship, but his campus interview was completed. And his friend, along with that campus
interview was completed. Did he get an offer? Did he get an offer?
Abhishek,
No, we are not good. Council, there is a difference. People get 1 crore also and people get 20 lakhs also in the same campus interview. Just because somebody has got 1 crore, will you say that you should be counted as 1 crore? You said you were selected. What was your offer in the campus selection?
But
Pay scale.
publishing MBA campus, but meanwhile,
They're asking you, campus, what was the offer to made to you in campus selection?
same as to Abhishek, which
How much?
I had done in P4, the affidavit of Abhishek.
How much?
40,000.
40,000
And that considered by the tribunal.
per month. And the tribunal has taken into account how much?
On page number 23, in L paragraph, in L ground, because of the Honorable High Court has in fact added 40,000.
Council, the income taken by the MACT is 40,000.
So future income added, if future income added, why was it only 22 years? MBA is completed. Future up to after 20 years, his income may be more than 1 lakh rupees. But we consider adding 40%, then 80,000 will be there. Then we added some
80,000.
Then 1
On
lakh.
40,000, if 40% is added, it will be 80,000.
No. So I have explained everything in para number L. Lordship,
We are not going to read para, Council. When you are making a submission, sound reasonable. You say 40,000, 40% will be 80,000.
22 years, but which income would be doubled. Hence, the learned claim
income would be double. Where is that formula you get?
To have considered
there is no formula of doubling. There is no formula of doubling.
80,000 income should be considered.
Trouble is that you don't listen, you don't answer, you keep studying. Dismiss. All next.
Lordship.
All next.
Lordship,
Sorry.
Lordship will consider. I aware.
The three questions I put, you did not answer. You went on to your point. So argue before this board. Argue before this board. We are moving to the next board.
Lordship, think I accept Lordship.
I accept that what?
I accept Lordship.
Every three questions I put to you did not answer. Council, if you don't know how to address the court, suffer. Your client should suffer for the fault of his advocate.
Mother client Lordship.
Mother client.
Client is.
When we asked you what was the difference, 40,000 plus, what is the percentage to be added? Future prospects. A formula has been laid down in 3 cases.
40.
Magnum, Sarla, and the other cases, what is?
In Vimal
Sarla
versus other.
Tenacity and Magnum.
Yes.
What is according to the formula, where do you fit it for future prospects? Absolutely not prepared. Read those 3 judgments and come. After some arguments, Lord Counsel for the petitioner prays for time to be fully prepared with all the judgments relevant on the issue, in which specific formula has been granted with regard to computation of compensation. Paragraph. In view thereof, as paid for, let's give a date after 4 weeks. I'm fully prepared. Yes, next.
Keep your plan.
Yes, my lord. In this case, my lord, this was only 33.
Counsel for the insurance. Who is the counsel for the insurance?
Yes, my lord.
Not in the other case. You may have to answer.
Yes, Lord.
If 40%, 40,000 is being taken, then minimum, I think it is 40%. And then the multiplier factor also.
Lordship, one thing I have to submit before this honorable court, the learned tribunal awarded the amount of rupees 45 lakhs 50,000. Against that order,
I know that, counsel, we know that. You don't have to tell us. We are asking you a limited question, whether that is satisfied or not.
Please.
Come with that answer. Probably that has not been done. Yes.
My lord, I am appearing for respondent number 2 in this matter. As per last office report, my lord, respondent number 1 has not been served. He is the owner of the insured. He is the insured, and liability has been passing upon him only, my lord. As
So that person is the main contesting respondent, counsel.
Not required, my lord. My respectful submission is that, my lord, kindly come to the page 13, my lord. So according to the police report, the list, not required, the vehicle was well insured by the New India Insurance Company, my lord.
So the police will say it is well insured.
Yes, my lord.
Police is a competent authority to give that finding, that it was well insured. Will we go by the police? If that is your understanding, counsel, then
yes.
Then it is dismissed. If that is your point, we'll note down. Lord Counsel for the Union, note down your point and we'll dismiss it on this.
Okay,
That is on
grant me time, my lord, for the interest of justice, kindly
the
grant me
police
time.
will now justify that it is covered by the insurance.
Just submission, my lord, my humble submission, not the final.
Not a final. Then when you're observing the natural reserve, you start arguing. Argue. We want points. Fit case to be dismissed in half a minute.
My lord, deceased was only 33 years old, my lord, 6 dependent.
At the outset, I prayed for by Lord Counsel for the petitioner. Yes, what were you saying?
My lord, the vehicle was not insured on the date of accident, and we are not.
What do you mean not insured?
Courts below has.
What do you mean not insured?
Policy was lapsed, my lord, much before the date of accident, my lord. It has been comprehended by both the learned courts.
In view of respondent number 2.
Yes, ma'am.
Who is the owner of the vehicle on who?
One is owner, my lord. Two is I am two insurer.
Who is not served?
One.
Respondent number 1, who is the owner of the vehicle not being served, especially in the background that the entire liability to pay compensation has been fastened on him, as paid for by Lord Counsel for the petitioner. How will you serve this thing?
My lord, kindly through the district court, my lord.
District court, now the matter is over. Where district court?
My lord, district court, kindly the process server will go and my lord, service will.
That has been done and not served. What is the reason? Not served? Insufficient address. The notice goes through the district courts only. Insufficient address. We are not going to repeat that process. It is insufficient address.
Well, kindly allow me 2 weeks time to collect the address.
To ensure service on the respondent number 2 and file
one man.
Respondent number 1 list after 4 weeks. No, 4 weeks. Take fresh steps. If it is not served, then you go.
Okay. Great.
Okay.
Yes.
These are here for the claimant to clear the
Balancing of the charges. Yes, please.
These are also. Notes here the claim which was awarded by the tribunal. Notes of 18 lakhs and order movements. That has been set aside by the interim order by the Honorable High Court in appeal.
On the ground?
It's on the ground that it has not been proved that the vehicle itself was involved, or whether the respondent number 2, who in spite of being served before the Honorable High Court as well as here, has not caused his appearance.
Correct.
How
is that going to improve your case?
He is
not appearing.
Yes, he is not appearing. He is not appearing.
That
so that will not improve my case. No, I just narrated the fact. Yes.
You gave a pass saying that his absence matters so much. I understood it like that. The tenor in which seriousness with which you presented that circumstance.
My lords.
But then
what is your claim? Why it was rejected by the High Court is a simple question.
My lords. So the answer is that his involvement was not proved, is what the Honorable High Court says. May I just take your lordship to the finding if your lordship on?
What is the evidence adduced by your claim?
So there are 5
witnesses. That the vehicle, subject vehicle, in fact, was involved in the accident.
So there are 5 witnesses examined. The employer, who happens to be a cousin, and other persons, number 3, not number 3, but 4 and 5.
Any FIR registered?
FIR was registered. That is after.
Vehicle number?
Unknown vehicle. FIR has unknown vehicle.
Yes. And that FIR was delayed by 45 days. I must say that as well, because that is also one of the grounds on which the Honorable High Court doubts the case of the claimant before lordships.
How do you meet that?
He was
for any accident resulting in this major incident, Do you want us to believe for 45 days the police would not be registering FIR?
Okay.
It is believable, counsel, especially in today's world.
FIR is registered. Offending vehicle could be unknown.
My lord.
Here FIR registration itself is delayed, isn't it?
Yes.
How will you get over that circumstance?
2017.
The only answer, my lord, which a plausible answer, but of course, my lord, that is not sufficient even, is what I feel. There was the petitioner claimant before her lordship, he was unconscious for 16 days, admittedly. But the FIR is delayed by 45 days.
20th day, if at all FIR is there, these details taper into that. In the course of investigation, normally I have gone there, hospital, examined him.
I'll add one more thing to it, my lord. So the claimant is not the complainant in the FIR. It is the employer who is cousin. He is the complainant in the FIR. So that is also one of the aspects which runs against hand.
Yes.
Looks like helping hand.
Seems to be so.
The moment an accident occurs, even if you go to hospital, the first thing they'll say, they'll inform the police that look here, a case has come, appears to be of accident, and we are proceeding with it. They will not leave their back open. Now, police is very, very strict after the order of the court with regard to this information reaching the police. So for 45, suppose a person dies, he doesn't have to fight, others will fight. The relatives must have come immediately. Take care of him. 45 days, counsel, 45 days, and then the complainant, the witness, everybody is the cousin. Then the cousin has to explain how accident occurred, why it occurred. What was he doing? He could not have been watching. He must be accompanying him, traveling with him. How can a cousin be on the road and that to the employer and only witness it and then sit back for 45 days? This circumstances also. We are totally with you. If you have suffered, you are entitled to it. No. But then, in this case, probably we are not ourselves convinced that it is genuine. Genuine in the sense that the allegation of an accident, that too by that particular registered vehicle insured by them, appears to be. No, as an officer of the court, now tell us. We may still be in time. Is there any indication in law as a court which may be little bit persuasive for us? Because as of now, I've been trying, my brother's also been trying to see from many angles, not one angle, many angles. You as an officer of the court assist. Counsel, do you think there was some ground, some argument to indicate that this accident took place by this vehicle? No.
I will try and give...
Because I will also try to look at both of us are very sensitive in these matters.
Lordship, right. I will give a very, very non-partisan view, Lord.
Exactly.
9:30 a.m. at a petrol pump, the accident happens. And he falls off. So, my lords, he is taken to the hospital by the same person who is informant in the FIR. My lords, he is discharged on 5th July. After 11 June accident, discharged on 5th July. The FIR is on 26th July. So, they catch hold of an Activa scooter of their neighborhood, my lord, and they decide to lodge this FIR. And when your lordship sees, I am not saying too many things, Lord. In the claim petition, only the owner is impleaded, the driver is named, but driver not impleaded. In the challan, my lord, the driver is challaned, but I am told for 6-7 years it has not proceeded. The witnesses to the claim petition, Lord, my learned friend's claim petition, have not come in the criminal case against the driver. So, my lord, there are too many things. In fact, we will not get to that level, but in one of the recent orders, your lordships have smelled something that this is happening across the country.
I have made an
Your lordships have sent it to an SIT that,
yes.
Lord, what is happening is that if there is a accident where either the vehicle runs away or not, they could not note the number of the vehicle, etc. So some vehicle is not set up because it is very easy. You just set up a vehicle.
One case came across that in a span of 20 days, that vehicle was involved in 40 accidents in 2 states. One of the cases.
Lordships have ordered SIT, they have brought that order.
There's an SIT, because the Honorable High Court's party.
That was shocking. That was either it was 40 days, 20 accidents by the same vehicle, or something like that. But shocking.
Even for one state of.
We are concerned with fastening the liability on the happening of an incident. Only then their obligation.
Certainly.
the moment that basic
That's why the moment your lordship put me a question with regards to involvement or what.
No, would you like to? No. Would you like to take further instruction and work on it?
I'm sorry.
Would you like to take further instructions and work on it? To get something. Because both of us and as an assistant officer of the court, he also said, we've tried. That is why we're discussing. And we're taking so much of time. If this has happened, then you are attacking this. But the thing is, nothing is even indicating. Not even indicative.
But in the first report at the hospital, they say it's an unknown vehicle.
That I told him that. I told him it's an unknown vehicle.
11, and then on 26 July, so it's a small city.
That benefit can be given.
Sorry, Lord.
That benefit can be given.
Yes.
What is bothering us is 45 days.
Come
back. Who sounded him about it? What was the occasion to get out of this truth?
Yes.
Then why only pick up a neighborhood vehicle?
First unknown and then replace it by neighborhood vehicle.
That's the.
That is settlement.
What happens is, Lord, of course, your Lordship know better. They will go and admit the claim in the claim petition. So this is what has happened. The owner has come, given a written statement, says that I was not driving it, my driver was driving it, and he was not driving it rashly. So that it is not an admission in the criminal case. But it becomes an admission in the civil case for the insurance company to pay. Then they don't support the prosecution lodge in the challan.
Sometimes it is the local police which is active in this. They don't fill up if it's unknown, don't fill up. Wait for 1 or 2 days. They have their own networks. And the network would be a vehicle from Bihar in Andhra Pradesh. Too tedious to be checked up. By the time the money is in the pocket, it should be Andhra Pradesh to Bihar, not Bihar. We have given, after hearing parties at length, we do not find any error in the order impugned. Any error in the finding that the vehicle in question is the vehicle involved in the accident as claimed by the petitioner claimant. So accordingly, the petition stands dismissed.
Right.
So deeply.
We'll wait. Yes.
Lordship in 24, it is about remission and premature release.
Yes.
Lordship had asked to take instruction.
Yes. In light of our direction at para 3.
Yes. Lordship, yes. The order of his premature release is already passed in 2021, which says he will be released after he completes 26 years, including remission. And the latest custody certificate, which we have dated 31st, is dated 2nd April 2025. So till 31st March 2025, he has completed 24 years, 9 days. 24 years, 9 days, including remission.
So how much that should be?
26. As per the GR of the state.
But actual incarceration, how much is required?
Actual incarceration is, your lordship, 15 years, 8 months, 17 days.
No, but your scheme envisages actual to be minimum 14 years.
No, your
No, there is a minimum for actual also. It cannot be that only with remission, but there is also a cutoff with minimum also. That it may be total composite should be 26, but then there is a minimum component of actual also in the remission scheme. That at least this much has to be actually.
There is a categorization looking into nature of the offense and everything. he falls in certain category, and accordingly in some cases there is only 24 years, in some cases
No.
there is 18 years.
We are trying to understand, not in this, we are trying to understand that as far as my knowledge goes, the impression I carry that every remission scheme has two components.
Yes.
It says it has to be maximum period for being eligible for consideration is X years, but out of which minimum of this year has to be actual physical. So in here also, does he satisfy the physical?
So yes, 14 years minimum.
That's what I'm saying.
Yes.
So that is satisfied.
Yes.
Now with remission also he has to have about a year and a half.
Yes. So after he completes 14 years actual imprisonment, his case for premature release is considered. When his case is considered, an order is passed that he will be released on premature release after completing so and so year, depending on the facts and circumstances of the case, depending on in which category he falls. So in present case, he falls under a category which the order is passed.
Where is that order?
That order is in Marathi, but I can read. I have
just read and explain it to us. Just read and
या अटींच्या अधीन राहून सर्व माफीसह 26 वर्षांची शिक्षा भोगून पूर्ण होताच मुदतपूर्व मुक्तता करण्याचा निर्णय घेतला आहे. So 26 years including remission. So once he completes 26 years including remission.
That date is not mentioned. That date is not mentioned. It only says then once he completes.
Yes, because he is now on bail. So his calculation stopped on some 24 years.
No, so as of now, out of that 1.5 years, how much actual he has to undergo and how much will be the remission given to him?
That jail authority calculates around after
what is the normal? Just an idea. Just give an idea.
Around once you undergo a year, there is around I think 90 to 100 days you get as
per year
as a remission. So I think he will have to undergo one more year.
3-4 months can be.
Yes, 3-4 months can be.
Yes, counsel. You're now at the flag end of the policy.
He will gain remission only if
when he is actually. Yes, that's what I'm saying. So another, what do you think? Because that is our tenor of the order says that we are only bothered with regard to remission, not on bail.
Wants to go back to jail.
You will have to undergo so that you carry remission on that.
Suppose if they file this policy where then we can also look into it.
Bring on record. So that
I will do that. If Lordship
because we had made our mind clear, that is why we were not interfering. You got bail from where? When you had come here?
Yeah. Same order. Because he was already in prison for some time.
Because we thought you were in 26 years.
You can go back.
Yes, but it's not an issue. We can.
Not as a counsel. Petitioner can go back to jail. No, anyway, we will come back.
And you know what persuaded us to grant bail? Because at that time we thought 24 years with remission, 14 years actual also, then definitely he will be covered. But then he says, even among that, there are categories specified.
I will file categories also. So
you do it. You explain it. You explain.
Yes,
you explain it.
You can see that when you saw that, suppose it is that.
Yes, point taken, Mr. Kaur. Yes.
It's item 24.
Just this matter we are still to dictate, counsel. This is 24. This is 24.
Yes, look, there are two offices. Totally 5.
What about 24.1?
Lordship, I don't have instruction. With similar instruction, I will file an affidavit with that respect also. But I am told he has also the order is similar to the petitioner in 24.
There are 5 issues. And 4 minutes through the first item. 1 minute through the second item.
That's why individually he'll place.
Yes, I will individually place everything on record.
He was more. He is more than 24 years.
Yes.
Same type of nature. So you are one step behind.
To take instructions.
Yeah.
Yes.
At the outset, Learned Counsel for the State submits that a decision had been taken with regard to premature release of the petitioners way back in the year 2021.
Coincidentally, on 5th August 2021.
Oh, on 5th of August 2021. Everybody, with regard to everybody.
Of 24, the appellant in 24, Rama Balu Mhase.
Has already been taken, but the same stipulates that as per the relevant policy of remission in which he has to, under which he has to be considered, the minimum period stipulated has not yet been completed.
Yes.
Which would include both actual physical incarceration and the remission granted thereupon. Full stop. However, to bring on record the details with regard to each of the petitioners before this court in the present two cases, as paid for him, the matter will be listed after 3 weeks.
Lodge. Great.
Give a date 3 weeks for filing affidavit explaining the position with regard to factual position with regard to each of the petitioners.
Along with the concern, the policy also, along with the concern policy.
I will place as also the policy under which such consideration has been made.
Great.
Yes.
One.
Yes. 41 who's appearing?
My lords, I am appearing for the petitioner.
Yes.
My lords, an adjournment slip has been moved by the respondent. We chose to give the NOC because the learned counsel had...
Well, who's for the respondent? Otherwise, is the matter ready for consideration?
My lords, they sought time on the last occasion to file counter affidavit. That has not come. The learned counsel, I had a discussion with learned counsel. He said likely that this might end up in the lady might agree for amicable resolution. But
what to do? This is the problem faced by the court. Nobody.
Well, the slip was moved by the learned counsel seeking an adjournment.
No, we're not talking about you. We're
please, well, sir.
Expressing our anguish. Every day we have to face this. Look here. Though learned counsel for the learned counsel for the there is a letter circulated seeking adjournment on behalf of learned counsel for the respondent. Sole respondent?
Sole respondent, my lord.
For the respondent. Put up, however, when the matter is taken up, there is nobody to press the same. Full stop. This court has been repeatedly coming across a situation, such situation, where learned counsel, after circulating letter, choose not to appear before the court, taking it for granted that as a matter of right, their request would be acceded to. Full stop. Such erroneous impression carried by a counsel itself speaks volumes, coupled with the fact that after accepting power on behalf of a party, it is their duty to appear before the court. And then the final call with regard to adjournment has to be by the court and cannot be negotiated or arrived at between the parties concerned. Full stop. Be that as it may, as nobody has chosen to press the adjournment motion, nobody come to press is here to press the adjournment motion on the one hand, and on the other hand, the necessity of the respondent being heard, we deem it appropriate to impose a cost of ₹5,000 on the respondent. Full stop. The same shall be paid, shall be deposited in the Advocate Welfare Fund of the Supreme Court Advocate Association and receipt filed within 1 week from today. Give a date after 2 weeks. Full stop. It is made clear that in the absence of there being representation on behalf of the respondent on the next date, the court shall proceed on the material on record and after hearing counsel who are present before the court. Yes, full stop. The learned counsel for the petitioner is requested to communicate the order to the respondent, counsel for the respondent.
Please, Milord.
Yes, next.
Obliged, Milord.
Please, Your Lordship. Lordship, I'm appearing for respondent number 1. I've entered my appearance last evening only, and I'm seeking some time to file counter affidavit.
Why did you enter your appearance? When was notice out?
9th of May and 10th of May.
May, June, July, August. Full 3 months gone. Why should we grant you indulgence? If your client has chosen to give you power only yesterday, it is for him or her to suffer the consequences. This is no ground that one day before they will give you power. Let them suffer for that. We'll close the right to file counter. Okay.
Your Lordship, there are documents which have to be brought on record. This is arising from a civil suit, Your Lordship.
Whatever you can't play with the court and take chances just because you are coming for the first day.
The other respondents are not here. The suit was dismissed against me for non-payment of Bhatta. The main dependent number 1 and 2 have not been entered appearance.
Doesn't matter. So they'll suffer. We'll not hear them. But we'll not give you grant time for this. We'll close. Because you've appeared.
Your Lordship,
so you have closed.
within 1 week's time.
No, not even 1 day. Why should we give this indulgence? Council come with the mindset that today we are appearing it yesterday.
The copy that was served upon me was served without any annexures. I have only received a copy from the SLP last evening from the council, my lords. My lord, we confirm from them.
So if you're
promptly, the copy that was received by my client was without any annexures, my lords.
Yes. Do you file copies without annexures in the registry? No, normally that defect would have been taken.
No, my lord, I can show it to your lordship, my lord, the defect.
It is your client's word. We don't take your client's word because the registry will not issue notice. We are getting matters. We are getting matters where it is defect is pointed out that incomplete set filed, so notice cannot be issued. Why should the registry act partisan? Why should they point it out? A lot of times, every week we get matters. The incomplete has been served. That is why notice could not be served. The registry has not pointed out. So,
Lordship, kindly consider, my lord, this is a matter in which there is substantial delay in filing of the SLP.
We are not getting you on leads. We are only closing your right to.
Your Lordship, kindly, this is a matter in which there was substantial refiling also, your Lordship.
That is for us between the court and the client, not for you.
My lords have also issued notice on continuation of delay.
Yes. So,
my lords have issued notice on both.
Let counsel for the respondent number 1 submits that she may be granted time to file counter affidavit as she has got received Wakalatnama only yesterday, full stop. In view of office report indicating that the notice was served on 9th and 10th of May and almost 3 months have elapsed, we don't find any justification for such request, full stop. Thus, we were of the opinion that the right to file counter should be withdrawn. However, by way of indulgence and subject to deposition of ₹5,000 cost, we permit the respondent number 1 to file counter affidavit. Let it be done within 2 weeks. Full stop. Payment cost be deposited in the Advocates Welfare Fund of the Supreme Court Bar Association within 1 week and receipt filed. Full stop. Matter be listed. So and so. Have other respondents been served or not served?
This item delivered to all.
9th of May, 10th of May.
Full stop. In view of respondents number 2 and 3 being served and still there being no appearance on their behalf, we make it clear that the matter shall proceed even in the absence on the next day, and further that no counter affidavit shall be accepted by the registry on their behalf without prior permission of this court. Yes, on next week.
So, Lordship, are fixing any date?
Who's filed letter of judgment? Item 43.
May it please, Your Lordship. I'm appearing on behalf of Petitioner, Your Lordship.
Yes.
We are seeking 4 weeks time to file rejoinder in this application, Your Lordship.
When did you receive the counter?
On 2nd of August, Your Lordship.
As paid for on behalf of counsel for the counsel for the petitioner for filing rejoinder to the counter affidavit served on him on 2nd of this month. List due date after 3 or 4 weeks, whatever.
Grateful, Your Lordship. Highly obliged, Your Lordship.
Please,
My lords, in this matter, certain property of the parties was acquired and a portion of it was released of 18 murders. However, that was not
was acquired and released. What do you mean released?
released
from
by the
acquisition?
Development Authority. And there was no demarcation done.
Was it released from acquisition?
From acquisition. From acquisition, your lordships. And at the time of release, there was a sentence that was put in that at the time of demarcation, there can be certain give and take, which will not be.
Let us understand. You use the term that the property was acquired.
Acquired.
Acquisition presupposes that you got compensation for the entire piece of land.
Yeah.
Otherwise, it would not be an acquisition. It will be only the process had started. Whether it was acquisition or it was only in the process of acquisition.
Your Lordship, there was an award that was passed later on, but this is arising out of a partition suit.
Answer the question of the court.
Your Lordship, I'll have to take instruction with respect to the.
Okay, as state formal and counsel for the petitioner to be better prepared, to be fully prepared on facts, let's give a date after 4 weeks. Yes, call next.
Certainly also not complete on respondent number 4 to 11.
In the meantime, fresh steps be taken for service of notice on the respondent number 4 to 11 within 2 weeks from today. Yes, next.
2045.
Yes. Wait, please. I've instructed for the petitioner. The after notice.
At the start, arguing counsel, what do you look at us every time you stand? You just look at us waiting. Start your case. Don't have to give the background after noticing that. We are not interested to know all that. Yes, what is the matter?
I've been working as a grade 2 electrician since for last 23 years.
Yes.
Without any promotion. As per the GO number 762, my lord, Finance Department, dated 1986. When, my lord, if I qualify with SSLC pass.
Yes, who's for the respondent?
I appeal to the respondent corporation.
Is it a fact that in the entire service career, not even one progression? Is it correct? Factually correct?
This post, my lord, is called selection assistant grade 1, grade 2. He's entered in that. Now, the next higher post, what happens is there is interlacing, 2:1 ratio. So 1 direct recruit and 2 by promotion. When his turn is, that's what the high court.
Oh, then in the meantime, there must be a provision for financial upgradation. Because he cannot be made to suffer stagnation.
As salary is concerned, it's not stagnant. It is, he's in fact gone up. I have the exact figure, my lord. It's about.
No, gone up by increments is not enhancement. Whether he did get a financial upgradation in his pay scale. Pay scale has to be upgraded. Normal increment is not
upgrade, my lord. It's the non-functional upgrade is what your lordship is asking.
Yes, yes. Financial upgrade, it's a personal promotion.
Right. I'll take him.
That you can't deny him that.
At
At least once you can't say that till the time, if it's not for 30 years he'll work, if there's no promotion post, he will not. You have to give him
there is a
promotion. In his own pay, in his own position, without upgrading the post, it will be a personal one, but then the financial band of a higher
stagnant
slot. Yes.
Yes. I will take instructions on that count and I'll find out what exactly.
Normally, every unit of the state, every branch of the state has a scheme for ACP, the PSUs and everything.
Right.
I will be surprised if the present municipal corporation does not have it. It will be a surprise to me.
I will take instructions specifically.
What are your instructions? You've not got any financial upgradation in your entire career of 23 years?
But my grievance in the petition is, I'm not promoted to the next level for last 20 years.
That is the only grievance. Then we can decide it here. If the post is not available, council, they will not create a post for you.
My lord, at page 50, para 8 of the High Court order, my lord, the Leonard single judge specifically says, my lord, that since from the date of joining, my lord, I have the necessary qualification. Therefore, within 3 months of the date of the order, that I should be promoted. And then
how can we promote it on a non-existent post, council?
There are because at page 50, para 7, there are 2-3 instances where the juniors got promoted, my lord. Those orders were there. It is
for promotion, it is not only time. For promotion, it is merit also is to be required. Yes. So if you are overlooked for promotion, you cannot have a grievance unless you make out a case that your case has not even been considered by the committee.
Yes, my lord. Yes. My precisely the point is that
the juniors have been promoted, his case has not even been considered.
He's placing reliance on a particular consideration.
Why are you taking us around council? First you said not in one. Then you said no, only promotion. Then you say, when you start asking questions, again you are, how you take?
But I'm asking my promotion based on my qualification.
Assert,
Yes. As per
but it is based on a right. Invite our attention to your right.
As per the government order issued by the state of Tamil Nadu, as per the government order issued by the state of Tamil Nadu, there is a two prescription for qualification. One is SSLC with pass and one is SSLC with fail. If it is SSLC with pass with the ITA certificate, then I will be a grade 1 electrician. And whereas if I have a failed SSLC fail and I have this, then it will be a second grade. And whereas, my lord, I joined in 2002, April 2002, my lord, as a grade 2 assistant. It has been last 23 years, my lord. I am working in the same place, my lord. It is not the instances that there were.
What is the finding recorded by the High Court on your entitlement?
Yes, my lord. Page 50, my lord, the High Court says I had the necessity qualification. Therefore, I should have been promoted as per the DO issued by the government of Tamil Nadu. That's all my grievance, my lord. And the, whereas,
why are you before us? If High Court has given such a direction, why are you before us?
Then the government went for a writ appeal, my lord. In the writ appeal,
you should only tell us what is recorded by the appellate
yes, my lord. In the writ appellate court, my lord, they said as and when the promotion that arises, we will give.
Correct.
But whereas, my lord, they just they just give the promise and they will not do it before 23 years, my lord. It is unbelievable, my lord.
The promotion matter.
My lord, there are cases, similar instances, my lord. I'm not, my lord.
Council, we want to help, but the thing is, you don't come within the parameters.
My lord,
how can it not the largest we are giving?
The government is not following its own orders, my lord, since
It says that you possess the qualification. If you have this, you are entitled to this post. That means your eligibility is not questioned. But then if the post is not there, can you say that I have to be promoted?
My lord, the juniors who have been promoted, my lord, that means there were posts.
That is not your case, council. That is not your case.
Have you overlooked, my lord?
That is not your case because the High Court in the writ appeal accepted that as and when the post will be available, you will be considered as there is no post.
In the writ petition,
has been accepted.
Where have you stated that the following who are junior to me have been promoted from time to time?
Yes.
Yes, my lord.
And where are the main respondents? Because then you have to make them respond.
Where the comparison comes?
Page 50, my lord.
5015.
Page 50, my lord.
Your affidavit starts from 31.
That writ petition order, my lord, where my the submission which and I also placed the lens of the similar orders passed to the same High Court regarding to the
similar orders.
You are going like this.
Oof. My lord, at page 50, kindly.
You are going like this. I am telling you, go straight.
Yes, ma'am.
The question is, where have you stated in the affidavit?
Yes, ma'am.
Just now you made an assertion. Yes. This is a case where they are treating the petitioner differently from than the juniors. Shows that definite allegation. Already I have folded the counter. Then I will go to counter.
Yes.
That was not the basis at all.
To change
para 10, page 33, para 10, Lord, in the writ petition.
I use Karna.
Side, I don't know why.
Please read the government.
Yes, my lord. Para 7 onwards, my lord.
No, please don't say onwards, counsel.
Yes, I'll read, my lord.
Just on the dot.
According to the orders of the government of Tamil Nadu, so and so they follow the same and.
You're reading page what?
Page 32, my lord. The writ petition affidavit, as my lord has asked him.
This is different thing. How the government of comparison with a junior is made.
At para 10, I humbly submit that the regional director of so and so, in that letter, the regional municipal attorney very clearly pointed out that GO so and so applies to me to be promoted from the post of electrician grade 2 to grade 1. In that letter, in paragraph 2, the regional director of so and so point out that already Mr. Rajamani, Muthukumar, Mani, Mohan, so and so, have been promoted from grade 2 to the post of grade 1. And it is more pertinent, important to mention that in the letter itself, the Regional Director of Municipal Administration, so and so, pointed out our GOMS number 123 of Municipal Administration and the orders issued in favor of the above said persons promoting from grade 1 to grade 1. And it has been ratified and their pay scale also revised as applicable to grade 1 on the sole ground that they have passed SSLC and they have IPS.
Are they not different? They are different from you.
Well, the qualification so far.
Read the next paragraph. It explains.
I submit that the Regional Director of Municipal Administration very clearly pointed out that I am also similarly placed and the case of mine may be considered on the same lines sent by the Executive Officer Kurmapatti in favor of me.
Similarly placed because you possess the same qualification. Yes. How does it matter? There may be hundreds of people possessing the same qualification. Only limited promotional posts are already less compared to the original cadre. In the cadre, it is like a pyramid. It goes shorting, and one person at the top. So just because there is no compulsion on the employer to give you promotion, you knew the department, you knew the structure. When you joined your cadre, the service, you know where you stand, till what level you will go, when you will superannuate. All these are known to you, Council.
9 and 10 explains this paragraph also. Paragraphs 9 and 10 of the counter affidavit. Page 40.
And they have been further promoted.
Naturally,
yes.
Council, please don't place reliance on that.
Yes.
It will not take you anywhere.
Yes.
You can make your case simple. What is the basis on which you are claiming promotion? Keeping 24 years aside.
My qualification. My merits.
Council, look here.
Yes.
On the basis of a seniority and availability, both twin conditions have to be fulfilled simultaneously. Not only one that I possess.
Is it that no vacancy has arisen all these years?
There are. He is also in the seniority list. That's what the Honorable High Court in the impugn order also said. When his turn is right.
We request you to answer the court. Please do not go in the circles.
Right. No, there are vacancies that your Lordship just pointed parent 9. In that also
when the due consideration for the petitioner would arise.
That specific date, I'll have to get back.
No, if there are vacancies, because always the consideration is in a ratio. For 3 posts, either 3 times, 4 times.
That's it.
So when does he come in the zone of consideration at least?
He's already in the zone of consideration. He's in the seniority list.
You are mixing up. There is ocean of difference between these two things, sir.
I'll take that specific instruction when he is.
Are you the standing counsel?
Hopefully. We'll take instruction.
Facts have to be very, very clear, Council.
I understand.
Expressions which have distinct meaning, all are being jumbled up.
I will get clear.
Only thing that bothers us is, though it is not question of rights, in the counter also it is not stated, look, you are not entitled to. It only says you are entitled to on your turn. What begs the question is, when is that turn?
Obvious from your counter itself.
Normal reply is, Selvanathan is the person to be considered. After that, the petitioner is the eligible. After considering petitioner's case, so and so will come. In that order, promotions are considered, and since it is based on seniority come merit.
Right. I follow.
Simple thing, why don't you get instructions?
Yes, I will give you. Okay.
At least let the petitioner know when the turn arises.
Right.
Because the division bench said on its turn, since he falls within the zone of consideration, it should be considered.
That's it.
When do you want?
May I have it after?
As jointly paid for list on give a date of 3 weeks.
Yes, I'm right.
Be prepared in the matter.
I'm right.
Please.
Well, just to
They're not talking about you, so don't get discouraged. Huh? No, sometimes you say we're smiling, that means something good. Don't be under that impression. Nothing to do with your case.
Just to indicate, my lords, before I say, the office report indicates, my lord, that respondent number 3 is not yet been served now. So it's been read.
So he is a contesting respondent.
Contesting respondent.
How do you propose to serve him?
No, it's Dusty, my lords.
Okay. At the outset, Lord Counsel for the petitioner submit that in view of respondent number 3 not being served, though being a contesting respondent, he may be permitted to serve Dusty through Dusty mode. Full stop paragraph. Permission granted. Full stop. Let the same be done and affidavit showing such service be filed within 3 weeks. Matter be listed. Give a date after 4 weeks.
7.
Next.
Please, my lords, appearing for the learned counsel for the petition, my lord. Here, respondent number 2 is not served, my lords, but before the learned single judge, notice to R2, he was R3 before the learned single judge, dispensed with at the instance of the contesting.
No, then you have to take a call. We'll record that if you want to dispense service, then it is at your risk.
Your lordships may kindly dispense with the service since it has been dispensed with by the learned single judge.
Okay. In view of office report indicating that respondent number 3 has not been served, Learned Counsel for the petitioner submits that even before the learned single judge, service to him was dispensed with, and thus praise that in the present matter also he may be permitted to dispense the service on respondent number 3 be dispensed with. Full stop.
R2 herein, my lords. Is R2 herein? Please.
Having regard to the faucet, the service on respondent number 2 is dispensed with for the present at the risk of the petitioner. Yes.
Please.
The others have been served?
Others served. Served, my lords.
Who's appearing?
None.
Respondent number 1 is served on 16th of May, but no
No appearance. Counsel, but we'll have to hear them. How can we? What do you propose?
Now, my lords, the petition before the learned single judge, my lords, is the contesting respondent number 1 hearing. The only person who has filed the petition for transfer. At the instance of that.
Correct. Then nobody is representing him. What to do?
No, my lord. My lord, she has filed a petition for transfer. That's true, my lord. She has been served because
Service is technical. Service is technical. We are asking you for substantive. We don't do anything. Being the final court behind the back. We take full precaution. Then ultimately we also proceed, but not at the very initial stage. Then she is the main contesting and personally it will affect her.
In fact, if your lordship permit me, it doesn't affect her. It was, my lord, set up by her husband.
Then
my lord, transfer petition is filed. May I submit, my lord, 2 sentences if your lordship permit me, my lord. Transfer petition is filed, my lord.
No, you suggest counsel. You can't be there. Whenever we start questioning you, you admit that if you go against her, then she is not required. This is not the way to assist. Can you serve Dusty?
Please, my lord, on
do it,
R1.
Do it. Let
on
us
R1.
decide that she has been properly informed, and then it's for her to take a call.
Please, my lord, sir. Dusty on R1, my lord, sir.
Just here. Further, Lord Counsel submits that R1 is the contesting respondent and has been served. And thus the court can proceed in the matter. Full stop. having perused the petition and the fact that respondent number 1 would be the affected party if at all the court is persuaded to interfere, we feel that one more opportunity should be given to the respondent number 1, and for ensuring that she is actually aware of the proceedings, we permit learned counsel to serve dusty notice on her and file affidavit within 3 weeks. Full stop. The notice paragraph, we make it clear that if on the next date the respondent number 1 is not present stroke represented, the court shall not give any further indulgence and shall proceed to finally hear the matter. Full stop. Paragraph. Learned counsel for the petitioner shall also enclose a copy of this order while serving notice on the respondent number 1. Paragraph. List on, give a date after 4 weeks.
Grateful.
Yes.
I beg to appear for petitioner here. On the last occasion, Lordship was pleased to issue the notice for the purpose of exploring the possibilities of the settlement. The other side is appealing.
Yes.
Yes, Madam. We have no objection if the matter in deputy mediation.
Supreme Court Mediation Center.
Please, sir. Please, sir.
Okay, at the outset, learned counsel for the parties agree.
What is your client doing? What is your client doing?
What is your client doing?
So she's a housewife.
Expenses you have to bear.
So I have been suspended because I was put in the judicial custody for 2 days. So I have been suspended.
Then you get subsistence allowance.
There was also a
Starting with
in the maintenance.
How much?
So we are paying 6,000. 12,000 rupees. 12,000. 12,000 rupees per month. Interim plus.
But traveling has to be over and above because you are wanting mediation here.
So I'm only getting 23,000, your lordships, because of suspension.
When were you suspended?
Because they filed a
When?
in 2023, your lordships.
You were suspended in 2023?
Please.
Then counsel, your instructions are incorrect. It starts with 50, after 6 months it increases to 60, then 70, and now you must be giving 80%. 2 years, in 2 years, it is little bit less than the original. It is not a flat 50%. And you take your instructions first.
Paying salary of 34,000, and now because of suspension, I am told that I am receiving 23,200.
As of
That is
now,
instructions which I am receiving.
you are totally incorrect. I am 100% sure.
Mediation, how much?
So it is your idea. If she is agreeing to it, you will have to ensure.
Should we refer to the mediation will do the best?
You are coming from where?
From MP Maharaj.
Pimpri, Madhya Pradesh?
Near Gwalior.
Gwalior. You have to bear some cost. Likhe.
Minimum expense, whatever the lordship decides.
At the outset, on a suggestion of learned counsel for the petitioner for sending the matter to mediation, former learned counsel for the petitioner readily agrees to the same. Full stop. However, it was submitted that the wife is receiving only rupees 12,000 maintenance for meeting her day-to-day expenses and thus may not be in a position financially to bear the cost of coming to Delhi for mediation. Full stop. Paragraph. As the request has come from the side of the petitioner husband for mediation before the Supreme Court Mediation Center in Delhi, we find that the respondent wife would be entitled to reimbursement of the expenses toward boarding, lodging, and transportation. Full stop. Paragraph. Accordingly, the matter is referred to the Supreme Court Mediation Center. Full stop. Parties to initially appear physically before the SCMC on when do you want? After 2 weeks?
Please,
On 19th. 19th of August.
19th of August.
19th of August at 2:30 p.m. Thereafter, if a request is made for participating in the mediation through virtual mode, the learned mediator shall take a call on the same. Full stop. However, comma, as indicated above, for every visit the respondent wife has to make to Delhi for the purposes of taking part in mediation, comma, she will be entitled to be reimbursed with an amount quantified at how much? 15,000? 10,000. 10,000 more than 7,000 per 7,000. Full stop. The first installment be transmitted directly into the account of the respondent wife by the petitioner by day after tomorrow. Let learned counsel for the respondent provide the bank details to learned counsel for the petitioner by tomorrow. Give it by tomorrow, by day after tomorrow you submit. Paragraph, learned mediator is requested to submit a report within 2 months. List your date. Yes. Yes, 49. You have filed. This is today only for early hearing. Huh? Today it is only a petition for early hearing. We'll give you a time. You have filed a petition which is listed today is only for IA for considering the early hearing. 49.
Yes, 49.
49 today. It is only IA number 163519 has been listed today, and that is seeking early hearing.
It is only for early hearings.
They are putting a question to me. Don't you see the cause list?
No.
We are more prepared. I don't even look at the cause list.
Lordship,
But sometimes your eyes goes without even saying.
I'm ready to argue, Lordship, but
You're ready to argue? Who asked your readiness, counsel? We have to be prepared to hear first.
Lordship, matter may be taken up any day, Lordship, wherever your Lordships.
Yes, we'll have to because it's a home buyer with out on the road.
No, I'll just point out. That is what I've just come with this chart. If your Lordship see this, maybe the issue can be settled in 5 minutes, right? I'll just
tell us.
So this is pursuant to your Lordship's order, the details of whosoever we have given, what remains, etc. So your Lordship will just have a look at this. Passing.
Yes, if that is there, then we can.
That's exactly what I'm saying.
Because in your interest.
Correct. So therefore, the whole idea is this. And there are three orders.
By now is understood how the court's mind works in these matters. So I think he should have been reasonable when he started.
I have come with a very fair offer and I'll point it out to you.
Very fair. Fair means what?
But if your Lordship may see, please have this chart.
7 years delay.
I have to be very careful of what I'm saying.
Come later. At least get what you first. Get what you.
Please.
Yes.
Total number of home buyers were 48 flat buyers. Out of which, the latest status is 43 have already taken possession. After that, there are 3 people who have not paid the full payment and they have refused to take possession. 3 people, their numbers are also given pursuant to the list. After that, we have compromised with one other person, and there is one termination which we had carried out. Your Lordships had in the last occasion directed that you keep a flat for him, which we are keeping safely. That's your Lordship's order.
So now you have to take instructions only with regard to 4. 3 who have not yet come and 1 who has been terminated. Only with regard to 4, you take instructions as per this chart and come back to us. Is right?
Lordship will come back. May I just, since my Lordship
yes.
has been
with regard to other, now your grievance is over.
Lordship, this matter, Lordship, may I just, this is a...
No, tell us.
Covered. This is a covered by another bench of this Honorable Court, class action litigation, and the identical same agreement.
You are very correct. Now what else? You have got possession. Only 4 remain. So with
interest and compensation and undivided share in the land.
That you will get.
Compulsory.
I would have to say that obviously every flat buyer has an indivisible.
That's not even an issue.
That's not even an issue.
May I just thumb rule? I was suggesting, if my learned friend will just bear with me, I'll put the solution and then please. I'm suggesting, please see the impugned order for a moment. impugned order in an original proceeding has refused to adjudicate. That is the first thing that I put it to them. That was unacceptable. The first court is saying that, no, I'm not going to hear it. Original complaint filed there. I'm making a humble request, now that the possessions are delivered, they already have a roof over their head. There are only 4 people. I will put all of this on an affidavit and file it here. Let the matter be remanded back to the NCDRC.
No. We'll close it. If it is covered by a earlier decision, similar.
It is not covered. I will distinguish it. I will distinguish it.
Please. What is this, counsel?
Oh, sorry. I just wanted to tender your lordship. In fact, there is a judicial order of his lordship on the very first day. Place Civil Appeal 8418 before the court on the very first day, 28th of July.
Listen,
so there
are senior counsel for the respondent at the outset passes across short chart indicating that out of the 48 petitioners in the present case, 43 have taken possession of the flats. 3 have been offered.
Because they have refused to accept it.
There is no lift
because they have not
taken possession by paying balance sale consideration.
Correct.
One has compromised and another, with regard to another, the appellant number 24.
We terminated.
The agreement has been terminated. Full stop.
In breach of interim order.
There is no breach.
7th November
Paragraph.
2023. There is an order.
Learned counsel for the appellant submits that with regard to the same building in question and the same agreements, common agreements between the parties.
Because the agreements are separate in terms of date.
How will that?
Same day.
Similar, the
Same
agreement,
project.
the
Same
agreement
respondent.
being the containing the same stipulations.
It's a class act.
The lordships may record my objection to that. I'm saying that the dates
It's a class
there has already been an order passed by this court in CA.
Civil Appeal 8418 2022 dated 25th July
2022.
2022. But order is 25th of July.
Yes.
Order is 8418
8410 for 2022 dated
25th of July 2023, and it is
in
recorded
which
with the very
compensation and interest has
it's a class action. It is binding on all the
either you say or we speak. When we dictate, nobody can speak.
lordship. By power.
You should know that it's our proceedings and we are in control.
Lordship.
If you don't do that, we'll have to put you to it.
Absolutely, lordship.
Then every time, the moment I say one word, you said 5 words. There's a limit to it, counsel. Yes, where were we?
Which compensation and interest has been awarded?
Awarded, the same order we passed in the present case as the other side has accepted the same. Full stop.
Look, I'm not accepting it.
Paragraph. The counsel for the respondent submits that he is in a position to distinguish the said order as far as the present petitioners are concerned. Paragraph. Be that as it may, let counsel for the respondent bring on record his complete stand with regard to both the question of possession as also compensation / interest as may be required if at all the court finds that the judgment referred by Learned Counsel for the appellant is relevant and is required to be adopted in the present case. Full stop. Let both the sides, it is open to the appellants also to file a detailed affidavit in this regard. List your date 3 weeks. You place on record everything. Your answer is very You also bring on record how?
May I make my-
We will be trying to make a distinction.
May I make my opposition right now? Because
Lordship,
the documents have recorded that.
one last point.
My lords, these people, the exact same people, were before this honorable court in that earlier round of litigation asking for the same relief. That relief was not given to them. Their
Why?
ideas-
Why? Because they filed. No, they must have said you file your own.
Exactly.
Now
That's
they
exactly
filed
what
a substantive.
Therefore, what I'm requesting is this. That
If they found substantive, then why should we not?
No, well, for
Here also don't ask people to
exactly my point. Your lordships are exactly the same thing that I am saying. Substantive petition before the National Commission, with respect, has not been adjudicated.
No, that is rejected outright. We will not go for you. Know this court too long. For too long,
This
Mr.
is what this is what.
Let it be. Let it be. We don't see any judgment.
I'm only pointing out the impugned order. The impugned order records that.
Whatever is impugned, that is why it is impugned before us. Not even 1 minute glance. You know, ultimate, we have to do justice and substantive. We are not in technicalities. Go to the national, come through state, then again show your head in the Supreme Court. Nothing of that sort. If it applies on the facts, it applies. Period. Yes, 3 weeks. Get a date and quickly go and persuade your client so that you don't face volleys, double engine volleys.
Lordship, my last point, Lordship, last point. If you are my Lord, is to permit. Lordship, here the.
You tell all your points so that he blunts your points today itself.
Lordship, no, only one.
All your points are being blunted by him. You start with a very sharp point and then nothing is there.
Only one point. The Lordship, the landowner. Everything is happening in the name of the landowner. Landowner has executed the power of attorney in favor of the developer. The landowner appeared before the 3-judge bench. In fact, Mr. Deve's counsel appeared on behalf of landowner.
Yes.
So therefore, your Lordship had issued notice on 14th of August when the learned counsel stated that after I have signed the agreement with the developer and the where I am out, Lordship, the agreement, the construction agreement and the agreement for undivided interest in the flat are co-terminus. This is a part of the
Council we observe.
Lordship.
And tentatively, Mr. Swab also was not readily rejecting that point.
Lordship.
Why are you putting that again?
Lordship.
It was discussed.
Lordship.
Now let him.
I bow.
He has enough to satisfy and convince. Don't add to his problem.
Lordship,
Yes.
That respondent number 1 and 2 be directed to file. I'm
No. He is the main person.
You are for the.
That's the developer has to file that. I am the builder. I have to.
No, yes, that's what I'm saying.
Instead of respondents, will it may kindly
Respond number 1.
One is-
Restricted to respond number 1 and 2.
highly obliged. Highly obliged.
He is here. How you saying is not? He is here.
Good. May it please the Lord.
Just call it 3 items and just quickly give that. Yes.
Please.
Yes.
Yes, sir.
Yes. When do you want?
Next week.
2 past 4.
Not next
Even next week.
Already we are overcrowded.
Today I was not guilty of the Passover. Today I was not guilty of the Passover. I made it a point.
We are not saying anything.
No, last week I had.
Come here. You'll have to give. All dates are all 40 plus. Give a date. As paid for, we'll put it on you then.
That's last time they sought for an adjournment. We were here.
That is the thing now.
They have always said jointly prayed for.
As paid for by Lord Counsel for the respondent.
Lordships should recall this to that.
Give a date of receiving. At the request of Lord Counsel for the respondent.
Not less than 1 hour, both sides.
No, more than that.
Ah.
More than that.
This
Because you'll
matter
have to
will
go into each and every. You'll have to go. Yeah.
And I'll be very
The
brief.
request was saying, matter will should give a date. Yes, next.
Lordship.
13.
Yes, sir.
Worship, this is a matter where this already, it has been there on page number 88. It is given, the statement has been given where it was proved that even the map is given where it is proved that they were coming from the wrong side.
No, we had asked for that time we had asked for the map.
Your Lordship, I have filed 91 pages.
Okay, as paid for and counsel for the respondent, yes.
Yes, sir. In item 13, the senior counsel has led in court number 2, so I was seeking a short accommodation.
So you will wait when we hear her, when we put questions, then you say.
No.
Or I not supposed to say at the very beginning that you decide.
I was supposed to at the very beginning, but the podium was filled with the senior counsels on matter 12, so I didn't get the chance to appear in it.
No, here today also, when we were hearing, could you have said that? We applied our mind, we asked her, she said page 81, we went to page 81, then we call upon you, then you say, time, is this the time to ask for?
I apologize.
Immediately when the case is called out, you have to ask for time, counsel. You don't know these basics?
I apologize, sir. I apologize.
Basic manners and the way an advocate conducts himself in court? You don't learn from the senior, straight away just come and just by your own thinking? You'd waste your time and then we'll accommodate. We'll impose cost of 50,000 on you then.
My lords, I'm extremely
Yes.
sorry for this. I did not do it intentionally. My intention not to do that.
No intention, but you have done it.
Sir,
So you pay for it.
Sir, I apologize for that. The
Okay.
only reason I
As
appeared
paid for well and counsel for the petitioner, give a date after 3 weeks. Yes, next. Yes.
14 your lordship and not matter. That's zero benefit of zero.
No, 1 second. The last point at which the matter stood adjourned was, he said a few cases are there. He desires to give the numbers of those cases.
That's right. That two things I must. And he was also to respond on logics, where the High Court has decided in their favor. He was to say whether they challenged that order or whether they implemented that. He was supposed to.
Mr. Vikas Singh says he normally does not remember. The way how he remembers it baffles us. In fact, even before we put the second question, he is alerting us that there are 2 points.
Correct. I bow down to that. Before I say a word, I must answer the 2 queries your lordship have put.
When do you want? When do you want?
Whenever it is convenient to my lord, I am comfortable every day.
Give it after 3 weeks.
This is already been.
I have jointly paid for. But to give that what we asked.
I have to make a submission, my lord. That's on 0 period, but not relating to this bird sanctuary.
No, we want, does not matter. 0 period itself is a big thing.
Oh, how to be computed?
See, again, the trouble will be different adjudications will come. Give the numbers.
I will give the number. There is no difficulty, but it's not relating to the bird
Agreed.
sanctuary.
May not
And
be related to this case. At
And
that time,
second query, what your lordship put to me, my lord. Logics, the order was a direction to the CO to decide. The CO rejected.
have not opened the brief, keeping in view what has been stated in the preceding paragraphs.
And only you wanted us to see those
It was rejected, then they filed a revision before the state government, that has also been rejected. Against the rejection, earlier they had approached the High Court, withdrawn their writ petition. I have those documents today. But if my lord permits me, it's not on record.
List it on record.
Finally, what you want to say is, even if it is understood that they are partly successful before the High Court, finally the relief is not given to that person also is your argument.
Well, they filed the writ petition.
That is your argument, isn't it?
The High Court has, we have not granted zero period to anyone else either.
As paid for filing, for being on record, for filing further affidavit. You already filed a counter.
Counter was already on
For further affidavit, better be listed, give a date, 3 weeks. Yes. Yes, it
Could
is.
it be high on board that is that was already parted?
Give a date on Wednesday. Wednesday we have very limited matter.
Very.
Hearing. Yes.
Why that priority is not given as much as possible?
Your lordships. Your lordship,
it is taken up not here only.
No, we will not.
Yes.
Well, additional documents will not be forwarded. I'll place.
Yes.
Whatever you want to.
Great.
Whatever.
Everything.
Great.
To place on record additional documents on which he would be relying.
Great.
Yes.
Item 18, subject to my lord's convenience to 19th of August. Subject to my lord's convenience.
We will adjourn it. It'll come after 3 weeks. Next recruitment board. Yes. As jointly paid for, list on friends.